Good morning.
Thank you. This trial is the matter of case number CFI 055-2020 and is being held by way of video conference before His Excellency Deputy Chief Justice Ali Madhani. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Hadif and Partners. Lead counsel is Mr. Karim Mahmoud. The defendant is represented by MB Kemp, LLP. Lead counsel is Mr. Salah Mato. Would the judge and counsels please confirm that the situation is as I have stated?
That's correct.
I confirm that's correct as well.
Thank you.
Very well. Well, very good morning again to you.
Good morning, Your
We
Honor.
have an interesting hearing today about the interesting interest rate here, and I guess we do have, it's like, I think we have things related to the applicable law between parties to whether it's UAE laws, including but not limited to the central bank regulations, civil law, commercial law, and then I think some of the JAVSA free zone regulations too, and or at the IFC, like whether civil or common law rules, and gotta deal with the interest in a different way. So then we have three witnesses. I'm aware that this is a mainly legal action in regard of the
That's correct.
interest. It's not even about the interest percentage. I think it's about the legality of this interest mainly, and not about the quantum at all. I haven't seen any discussion about the quantum. And I've seen slightly there is an issue about the purpose of why the percentage of this interest rate is somehow, as it has been said, it's higher than the market rate. So, and I guess maybe, and correct me if I'm wrong, whether the witnesses are going to speak about that issue. Mr. Mato?
Your Excellency, from our perspective, the witness evidence is in a limited fashion required to confirm certain aspects of the company regulations and what the company was allowed to do and not allowed to do, so that it can provide Your Excellency confirmation of what the permissible activities for this company were in the free zone that it exists in.
Yeah, but why you need witnesses if it's in the JAVSA rules, if it's in the company's article of association, if it's in, I mean, if it's already in the witness statement, if it's not challenged by the other party, I mean, why do we have to go that?
Your Excellency,
that's far.
that is precisely the issue. The claimant has not confirmed that our position is correct vis-a-vis the permissible activities of the company. That has not been addressed in their witness statements, and that's why it would be helpful for us to get confirmation from the witnesses that since the incorporation of the company, that they have not since then changed the license, acquired any banking license or any other license in any of the free zones or in the IFC for that matter.
Your Honor, I can confirm that there is no such license obtained. There's no banking license. From the claimant's perspective, we don't really see a need for witnesses. We see this as being an issue just of law. I think the way we approach it, Your Honor, and perhaps in the interest of time, we view this as simply a DIFC law matter. There's just really one article of law that we're focused on for determining the validity of the interest. And if we perhaps deal with this as a preliminary matter, I think we can actually deal with this on a much more efficient basis. From the claimant's perspective, we don't need to speak to the witnesses to determine whether or not the interest rate was valid under DIFC law.
Well, I know you could have done this, Mr. Mahmoud. I mean, before the trial, you could have asked for immediate judgment determining this issue, and if it's a killing point, then you will have a judgment in your favor. Anyway, we are at trial today. We have a timetable. if both parties think there is a point from bringing the witnesses, but I would urge you not to invest a lot of things, a lot of cross-examination. So I'll allow you to take your part in the opening submission in turn. And then
I'm very grateful, Your Excellency.
I mean, let's hear from the witness. And I hope if it turns to be like the call of the witnesses is serving no point, Mr. Mahmoud, then it's, you know, what's the consequence of that. But if the witnesses did prove some point of change, or the fact they're bringing would have any influence in the decision, then that is justified.
Understood, Your Honor. I think from the claimant's perspective, it was, this proposal to address just DIFC law comes after the receiving the discontinuance, which came after the pretrial conference. So,
I see that happened very quickly. I don't know. There were a lot of development after April I mean, in regard of this discontinuous of the rest of the claim, the counterclaim, and then shortcutting the claim to the interest only, and then how to deal with the interest. They were a bit
Your Excellency, if I may, the defendant had conveyed to the claimant, my learned friend would confirm before the PTR that we will not be taking up counterclaims, and it was not something we disclosed to them during the PTR. We have, in good faith, had informed them about this. The formal discontinuance happened afterwards, but for the practical effect of what the discontinuance was conveyed to my learned friend and to the claimant before the PTR.
Doesn't matter. I mean, Mr. Mato, you still think the witnesses is important, eh? That's what you...
Just for a limited amount of questioning, Your Excellency. As you can see from the timetable, we are not going to take an extensive time with them, and I don't intend to spend more time than that's been allocated in the timetable, which is a very limited review of cross-examination as agreed. So I think Your Excellency will be benefited, I would say, from hearing the witnesses to get some understanding of what their understanding was for entering into a agreement such as this one, given the position of the JAFSA regulations and the laws as such.
I see. So, Mr. Mahmoud, I think the guarantee you get from Mr. Mato, your witnesses won't be interrogated. At the end of the day, they can go for lunch happily.
Understood, Your Honor. I think, from the claimant's perspective, this could be narrowed even further. If we're dealing just with issues of DIFC law.
And that's why we have the course at the end of the hearing. Okay. Yeah. If there's any other housekeeping or anything need to deal with, we discussed the order of the witnesses. I think we're fine with that as well.
Yes, we have, Your Honor. It's in the...
And from my part, I have read the witnesses' statement, submissions, and skeleton argument, opening statement. I've done my part. I mean, I'm aware of the background and the fact of the case. And Mr. Mahmoud, if you want to go, you go first for the opening submission, I guess. It's your turn.
Excellent, Your Honor. May it please the court. On behalf of the claimant, Your Honor, this claim concerns a loan agreement entered into the claimant and the defendant in July of 2019. The loan amount was received by the defendant, and the defendant acknowledges receipt. This is not in dispute. The loan agreement stipulated that the loan was to be repaid within 60 days. So this was a short-term loan. The loan should have been paid back by 3 September of 2019. The interest rate charged during that loan period was 24%. And then afterwards, there was a default interest of 36% that was to be applied. The loan agreement is subject to the jurisdiction of the DIFC courts. And we're here today because the defendant did not repay the loan, nor did he pay the full loan period interest or the default interest. Your Honor, we believe this is a very simple case. Notwithstanding that, there's been a number of applications that were submitted by the parties throughout the life of this case, which we feel has dragged this matter. So originally, Your Honor, there was a number of things in dispute. We know from the pleadings and the proceedings in the pretrial conference that these issues have now been narrowed to that just of the legality of interest. The point here, Your Honor, is that following the disclosure and exchange of witness statements between the parties, defendant's counsel has confirmed to the judge and to me that they wouldn't be pursuing any counterclaim or contesting the principal loan amount. Given that the defendant has also elected not to challenge the fact that DIFC law is the governing law of these proceedings, we believe that the remaining issue and dispute between the parties turns primarily on the interpretation of DIFC law provisions dealing with contractual interest rates. So it's our view, Your Honor, that this matter should be viewed simply from a DIFC law perspective in regards to charging interest. From the witness statements that have been submitted from Mr. Harsh Shah and Vinay Surana, it's clear that these interest rates were agreed between the parties. They were agreed to preserve the company's interest. If you recall, at the time, there was another outstanding loan from the defendant given by the claimant, and the fact that this was supposed to be a very short-term loan. The DIFC law, which applies to these proceedings, allows the parties to agree to an interest rate in a contract and doesn't place a cap. So the defendant, in this case, tries to argue that the agreed interest is null and void and constitutes an unenforceable penalty, in short. These arguments, we believe, Your Honor, are incorrect, and they are in clear contradiction of the law. The facts, in our view, are very straightforward, and it's clear that the defendant is attempting to use all the tools at his disposal in order to get out of paying a sum that should have been calculated on the basis of what has been agreed between the parties. We believe, Your Honor, that this has been evidenced through the defendant's conduct of the proceedings. Specifically, I make reference to the number of submissions made to this court that the defendant should be allowed to defend the case and that he has reasonable prospects to defend this claim, just for the defendant to backtrack 3 years later and submit in his witness statement that he will not be challenging the loan principal amount and also withdrawing the counterclaim. Your Honor, ultimately, the claimant believes that this is not an excessive amount of interest, as the defendant tries to portray. Short-term loans are given on what is deemed to be a higher interest rate. Again, this was a 60-day loan. And moreover, the claimant wanted to preserve its position, so it gave its conditions for granting a loan. And the defendant, who is a commercially sophisticated person, agreed to it. So this position is also supported by DIFC law and DIFC case law. Your Honor, the defendant has not relied on any DIFC law provisions to support his position. He makes reference to one DIFC law by way of JAVSA regulations, but does not primarily rely on it. If anything, the defendant's 8th witness statement shows that the defendant is trying to use incoherent and illogical arguments related to interest in order to support its position. Specifically, the defendant has stated and acknowledges that due to his inability to prove his claim with respect to the existence of an oral agreement, that he has no option but to pay the loan amount. This is an admission in itself from a party that is legally represented, and we believe it is a sufficient admission that there is no argument as to the validity of the loan stemming out of the claimant lacking authority to enter into the agreement. So we believe, Your Honor, that the defendant cannot later try to rely on the purported invalidity of the agreement in order to argue that the interest rates are void. If they've agreed to the agreement, they've agreed to it. Should there be a real prospect of arguing that the loan agreement is invalid due to the claimant being an individual, which is one of the arguments made by the defendant, then surely the defendant would not have agreed to paying the loan amount and would have used this same argument as a defense.
So are they arguing that the whole legitimacy of the contract or the term of interest only?
Your Honor, at this stage, we're arguing just interest.
No. From the defendant point of view.
Mr. Matu?
No, but I want to see how you look at their submission.
Oh, so Your Honor, you know, my point here is that they're arguing that they can no longer sustain a defense on the principal amount. So this admission can also be used to state that if you agree to the loan amount, you should also agree to the principal.
Right. Yeah,
So with that, Your Honor, the evidence that we've provided consists of the loan agreement, the witness statements of Harsh Shah and Vinay Sarana, correspondence between the parties, the payments made by the defendant towards the agreed interest, as well as the defendant's acceptance of interest rate calculations throughout the course of the loan, as well as the admissions made by the defendant in his eighth witness statement. So, Your Honor, it's the claimant's position that the defendant has no seriously arguable defense to support his position that the interest and default interest should not be repaid under the loan agreement. I remind the court that these proceedings were commenced in 2020, but were allowed to drag, and here we are 3 years later, without any substantial defense to the breach.
I understand.
Good. Well, moving on then, Your Honor, what I hope to accomplish today is simply to show you that the rates which were agreed upon are valid under DIFC law and should be enforced. Furthermore, I'd like to show that no discretion should be provided to the defendant due to his actions, namely the delayed payment of interest, because here we are 3 years later and the principal amount, although now the defendant has agreed to pay it by way of the consent order, the fact remains that 3 years after this loan was issued, the principal amount has not been repaid. So,
One question I have for you, Mr. Mahmoud. In your opinion, can the UAE onshore laws apply in the DFC without a party's consent to it according to the waterfall of the law applicable in the DFC?
well, Your Honor, I think if you're using the waterfall, if you find yourself in a situation where there is no DIFC law applicable, it's one of the options that you can look at, right? But here's, in this instance, we have a DIFC law that's directly applicable. And even then, it's not, it's something that can be taken into consideration, right? But it's not something that the court is held to.
No, what makes the DFC applicable? None of the parties are DFC parties, isn't it? Neither the transaction has happened here within the DIFC. We understand there is a reference or opt-in to the DFC court jurisdiction. And does that make the applicable law automatically DFC laws? The mere opt-in.
I would argue that it would, Your Honor. And I could also direct you to, if you have the hearing bundle available to you. Actually, this is a reasoned order from yourself, Your Honor, who's reviewed some of the arguments made in a trial, in a hearing rather, on 9 December. So if you go to page 133.
Section are you referring to?
Sorry, I'm working off of a.
I think it's section B3.
B3, page 133.
Yeah.
Paragraph 46, this court found that DIFC law applies by way of Article 30 of the DIFC law, number 10 of 2004, which requires that the DIFC court apply DIFC law in the absence implicitly of another law as agreed by the parties. So if there is no other law and this loan agreement is subject to the DIFC courts, automatically you would apply DIFC law. Now, the defendant may show other reasons or may attempt to argue that other laws should be taken into account, but by default we should be dealing with DIFC law in this instance.
And this has never been subject of appeal, isn't it, by any means?
This particular point, no. This was, you did grant permission to appeal this on there was an issue of service. And Justice Roger Giles agreed with that and allowed that appeal and granted that appeal. I also note that Justice Giles also had some reservations and concerns about the evidence produced or relied on by the defendant. And he also noted that had the claimant not consented to this, the submission of the defense, he doesn't see how it could have gone through. So yes, it was appealed. This point in particular wasn't challenged. It's never been challenged by the defendant subsequently. We've had a case management conference where it was confirmed that DIFC law applies. And there's been no challenge to date on the applicability of DIFC law. What you have is reference to other laws and why they should be taken into account, but DIFC law has not been challenged as the applicable law. If I can also direct your honor to page 129, just a few pages up.
$129?
129, your honor.
Yes, I'm in.
So
41, paragraph 41.
41, 42, and 43. So if you recall, your honor, the defendant made four arguments on 9 December. 3 of those arguments are no longer in dispute. They related to, a security check, a set off, and issues that we no longer have to deal with. The only one that remains is interest. This very court has looked at all 4 of those arguments, and at that time considered that there was no reasonable prospect of success. It looked at the issue of interest and also felt that there was no reasonable prospect of success. The reasons provided are here and outlined in paragraph 41, which I'll read in part. Mr. Sethi does not explain, however, the route by which UAE law applies in the DIFC. He also avers that NS Investments has waived its right to the interest in question, having failed to claim it as a part of the performance order sought from the Dubai court. It is unclear whether Mr. Sethi takes the position that, had NS Investments claimed for interest been included in its request for the performance order, its claim for interest would have thereby been rendered permissible. In any event, as NS Investments has submitted, Mr. Sethi agreed to the interest rates, and moreover, he appears to have made partial payment of interest that had accrued. If any right has been waived, in my view, it is Mr. Sethi's right to dispute the interest. I note in passing that had the security check been honored, significantly less interest would have accrued and be continuing to accrue. So, Your Honor, we're here 2 years later, and nothing has changed. The principal amount, the interest has continued to accrue. The fact that he paid interest, he made these 2 interest payments, he's agreed to the interest, none of that has changed. So, Your Honor, under DIFC law, we'll get to it and reference the relevant article. However, even if you wanted to rely on UAE law, the defendant would still not have a viable defense. The claimant is a company. There are some arguments made by the defendant that it should not be viewed as a company, but it's a company. And given that this dispute is governed by DIFC law, we believe this point remains redundant. But even under UAE law, a company is allowed to make a loan, it's allowed to charge interest. There's nothing illegal about it. And so that's our position on the UAE law.
Okay, if you're saying even under the civil law theory, which is the secondary one for your side, even if the company breached some regulation in the UAE that doesn't render the contract completely illegal, isn't it? That's what you're saying.
Sorry, Your Honor. So if a company is found to have breached the law,
certain regulation related to providing loan and interest,
well, that would have to be proven that this regulation was violated. right? And so simply, our position
And
is
in
simply,
that case, if it's proven a company have violated some regulations, regulatory regulation, maybe central bank, maybe the DFC regulatory framework or something, good contracts.
well, Your Honor, usually, providing evidence of that requires, showing that that there's been a position made by the UAE Central Bank, or a regulator has issued a decision on a particular point, simply claiming that, here are the regulations that should govern, and that the court should interpret those regulations, which are non-DIFC court regulations. That's a few steps removed from simply saying, this is illegal. So there should be a process, right? So if the defendant wants to claim that certain regulations should be recognized and enforced, they should also provide evidence that those regulations have been violated.
I see, but I think that's what Mr. Mato trying to do for the last 2 months. Okay, Mr. Kane, thank you very much for submission.
Your Excellency.
Your Honor, if I just walk you through the relevant DIFC case law, which I think is important.
I thought you've done, sorry.
Sorry. Well, actually, to go back to this point on UAE case law, so we have a few articles that I believe would be helpful to look at if the court were so inclined to take into account UAE law. In specific, there are Articles 72 and 73 of the Commercial Transactions Law, which state, this is Article 72 in specific, that the creditor shall have the right to charge interest on the commercial loan as per the rate stated in the contract. So if you have a contract and you have a loan amount agreed to by the parties and a rate agreed by the parties, then that is the rate that should be applied. Article 73 goes on to state that if there's an argument on the interest rate in the contract and the debtor is in default of the payment, the default interest shall be calculated on the basis of the rate agreed until full payment. So this is a concept that's also understood under UAE law as well.
But isn't that, applicable to those who are permitted to do this kind of business? It's not like anyone, you know what I mean?
Yeah.
You would first have to be like licensed to do this kind of business, and then you can rely on this contract. Provisions.
Your Honor, I don't think you need to have a license to make a one-off transaction for anything, right? If you're carrying on the business of, sorry, Your Honor, can you hear me?
Yes, I am.
Okay, there's a bit of a lag between the
I can hear you very well.
Okay, very good. So I think there's a difference between carrying on business regularly and one-off transactions. So companies make loans all the time. Companies provide housing loans to employees. Companies are allowed to sell a car that they own, even though they don't have car dealing on their license. The court is allowed to charge for photocopies, even though it's not a photocopy. It doesn't have these activities on its license. So the law doesn't account for one-off transactions. It's dealing with carrying on regular course of business. And I think when you look at the nature of those regulations, it's clear why, right? So the JAVSA regulations, for instance, JAVSA offshore doesn't have the capability of regulating financial institutions. So you can't have banking activities in JAVSA offshore, right? It's not something they're capable of handling. And so don't expect to get a license to operate a bank in JAVSA. But providing a one-off transaction is not something that's covered for by these regulations. So for DIFC, we're referring to Article 122 of the Law of Contracts. And I would just like to draw your attention to, let me pull up the exact reference. If the court would bear with me, I just jumped around a bit on the.
It's section G, number 2, 940, page 940.
Very good, thank you. So Article 122, subsection 1, states that where the contract provides that a party who does not perform is to pay a specified sum to the aggrieved party for such non-performance, the aggrieved party is entitled to that sum irrespective of its actual harm. So in an instance where the parties have an agreed interest rate, Your Honor, the application of 122 is quite clear. You just apply the interest rate that was agreed. I think there's no, the fact that the parties have agreed to this interest rate is not in dispute. The fact that the parties have acted on the interest rate is not in dispute. We have evidence that the defendant has paid the initial payments on interest. So the fact that the interest rate was an agreed term is not in dispute. And we're arguing that the court should hold this agreement, should find this agreement valid because of this article. Now, I will also note that Article 122-subsection 2 provides that the court does have discretion if it finds that the specified sum was grossly excessive in relation to the harm resulting from the non-performance and to other circumstances. So in the event that the court did find or had interest with the rate, the court also has discretion. And so this also marks a very a distinction between how English courts approach this versus the DIFC court, right? There's no concept of penalty under the DIFC law. What you have is discretion by the court to look into whether or not this was grossly excessive, and not just excessive, but grossly excessive in relation to the harm, but also taking into account other circumstances, such as in this case, the actions of the defendant, who there was a default judgment. He applied to set aside the default judgment and the immediate judgment. And then 3 years later, we're still in the same situation where there's no payment of the principal amount. So, Your Honor, I would also like to highlight one case that we've identified. Its the reference is CFI 047 of 2019. This is Caterpillar versus Omer Transportation. In this case, the defendant was attempting to use Article 17 of the DIFC law on damages and remedies to argue that the default rate of interest should be lowered to 9%. So in that case, the parties had agreed to an interest rate and the defendant wanted it lowered to 9%. Justice Roger Giles provided, this is paragraph 29, so I think the reference is F5 882 rather. He provides that in its application to post-judgment interest, ordinarily in the exercise of the discretion to order interest at a rate other than 9%, the court will order interest at a contractual rate of interest, if there is one, until the date of payment, because that is the agreement between the parties. So here we see the court respecting the agreement of the parties. He goes on to state that the 9% rate does not govern after judgment, let alone before judgment, in substitution of an agreed rate. So he's showing the strength of having an agreed rate in a contract, and that it's honored and respected by the court. In paragraph 31 of the same order, Justice Giles refers to the contract law and states that the entitlement to interest conferred by the article comes into play in the absence of an agreement for interest upon failure to pay. So here there is no absence of an agreed interest rate if there's a failure to pay. It does not deny or replace a contractually agreed rate of interest. So it just shows the strength of having an agreed interest rate in a contract, and that, you know, the application of this law upholds the claimant in this case receiving the 36% default interest as well as a 24% interest for the remaining period of that initial loan period.
And in that case, none of the parties are banks, isn't it, or financial institution? Can you confirm that?
Yeah, that's correct, Yana. You're talking about Caterpillar Financial Services. They deal with heavy equipment. You know, they provide heavy equipment. And then the defendant was.
Don't be dragged by the name, because some of these big companies have a financial arms, and then if they. Yeah.
Well, yeah, that's a good point.
Might look better, but they might have they might be licensed because they have plenty of money. Then they will be licensed to carry some financial. Some of them. I haven't seen the description of the party in the case yet. Yeah.
I will go back and confirm that point, Your Honor. They may, as you highlighted, just we shouldn't assume because of the name. I will confirm that point.
Yes.
Well, Your Honor, I would also, just before concluding, highlight just a few points that I think are relevant in terms of deciding whether or not the court wants to use any discretion. So had the defendant paid the loan amount and default interest at an earlier stage, we wouldn't have this very large sum that we're dealing with in terms of interest to be repaid. And I'd like to highlight that this is not the fault of the claimant. It's not a result of the interest rate being 36%. It is the result of the defendant failing to pay the principal amount in 2019, in 2020, in 2021, all the way to date. And just for illustration purposes, had the defendant delayed in payment for 4 months on the principal amount, which was just under 1.3 million. If he was 4 months late, he would have paid $154,000. This is just under 12%. Right. So if he had 1.3 million for 6 months, he would have paid $154,000. If he paid as a result of the default judgment on the day that the default judgment was obtained, he would have paid $471,000. Today, as of the date of this hearing, he would have paid 1.792, 402. I mean, this is an incredible sum that is a direct result of the defendant failing to pay the principal amount, which he's agreed to pay at this point. Right? There's no defense to this. He's paying the principal amount. So with that, Your Honor, I stress that should be taken into consideration. That the defendant had within his ability or rights to make this payment earlier and not expose himself to such a high amount. So with that, Your Honor, I'd like to simply conclude that this is a straightforward claim for the enforcement of contractual obligations. We believe that the position is very clear under DIFC law. Again, I ask the court to take into account the defendant's action in these proceedings. We continue to stress that 3 years later, the defendant still doesn't have any defense for having not paid the principal amount to date. And the fact that the interest has accrued and has become such a high amount, more than 3 years, is really due to the defendant refusing to make payment. And with that in mind, what we're seeking is a declaration that the defendant has breached the terms of the loan agreement and that the claimant is entitled to repayment of the loan amount and the interests accrued, both at 24% for this small period that there's still an amount owed, and for the 36% for the entire default period up until the full principal amount is paid. Your Honor, we'll also be seeking costs on an indemnity basis as a result of the defendant's actions. We think that's fair given the situation. And this has been agreed at the pretrial conference, but we would like costs to be assessed by way of detailed assessment after the hearing. And with that, I rest, Your Honor.
Thank you very much, Mr. Mahmoud.
Your Excellency, first of all, I want to make a housekeeping point. My learned friend has taken over 30 minutes to do his opening statement. That's not what was agreed in the timetable, but I understand it was for Your Excellency's benefit. So I just request that the defendant also be allowed similar leeway in time.
Well, I want to make. If you prepare to deliver in 15 minutes, I won't ask you any question.
Your Excellency, you're very kind. I'm sure you'll have some questions, and I intend to fully cooperate with you. And second housekeeping point I want to make, Your Honor, is
just for the record, I mean, Mr. Mahmoud, my assistant just informed me the Caterpillar, in that case, the DFC case, are licensed to carry out a financial services. You may check from your side. Yes, Mr. Mahmoud.
Thank you, Your Honor. I'll look into that.
Secondly, my learned friend referred you to Your Excellency's decision in this matter. which was appealed, and it would be correct to say under any rules of natural justice, it was set aside. So the matter started afresh after that. So referring to something that was set aside, it would be grossly unfair for the defendant to be relying on something which is no longer which was set aside by the Court of Appeal. Having made those two initial points, I just want Your Excellency to review all the material afresh based on the submission of the parties, and then reach a conclusion. And any assertion of my learned friend that you should go back to a decision that was set aside would not be appropriate. Your Excellency, the licensing structure in the UAE matters. It matters because it gives certainty as to what is permissible and what is not permissible within the UAE. There's no concept of one-off means of doing whatever you want to do as a company in any free zone or in UAE onshore. There's a reason why there's a licensing structure within any jurisdiction. It provides certainty, and regulators look at those things very carefully when giving a license. What are you appropriate? What is the appropriate license you can get for whatever you're doing in a given jurisdiction? So the claimant is a Jabal Ali free zone company, which was incorporated in 19th of January 2016, and its only purpose, Your Excellency, is to carry on the business of general trading, owning properties as permitted by JAFZA, namely at the Palm Islands, Jumeirah Islands, all or any properties owned by Nakheel Co. LLC, Emaar Properties, Dubai World, Dubai Holdings, and any other properties approved by the authority. To be and to act as a holding company and to do investments in shares and to purchase and sell real estate properties as approved by the JAFZA rules. Nothing beyond this they are allowed to do. Now, my learned friend just glossed over the fact that there are rules and regulations of free zone that do matter to a matter in DIFC codes. DIFC codes have to look at a company and see what is it permitted to do in a jurisdiction, by that matter in the UAE. I would like to point out to you.
Say that again, Mr. Mato.
Our submission, Your Excellency, is that the DIFC codes have to look at the rules and regulations that govern a company. What is it permitted to do? What is it allowed to do? What capacity does the free zone give it to do vis-a-vis transactions, vis-a-vis permitted activities?
And what I have to do with that? I mean, I will give you example. I mean, I have a dispute between Chinese and Brazilian companies, and it was argued before me when one of them breached Chinese law. But in the contract before me is a completely commercial transaction. Why I would look at the breach of Chinese or Brazilian some financial regulation?
It is important for Your Excellency to be satisfied that the party or the parties had the capacity to enter into an agreement, to a said agreement. Whether that agreement can be entered into, formed by the party, advancing that agreement, preparing that agreement.
Well, capacity is a very wide. It's very wide word. I mean, you're using, Mr. Mato. I mean, capacity to get into a contract and capacity to do business, capacity to be licensed, capacity is a very wide range, ranging word, I guess.
Your Excellency, in the context I'm using the word capacity is it permitted? There are certain activities that are permitted by every free zone. If it was the case that you would be applying for a general license that would allow you to do everything, there would be mayhem in any jurisdiction. And the courts have to look at that and see. It's not just merely looking at, okay, if there's a document, whether it's a legal document, whether the document is legally enforceable or not. there could be a DIFC agreement for a lack of better expression, for slavery. But with all due respect, that will not be, even though there's a document that's tantamount to giving effect to slavery, you have to look at the law behind it and say, is it permissible, that sort of contract? And that's when we look at the rules and regulations and the laws prevailing.
And in this case, you're arguing a very high threshold. It's a forbidden what they are doing, isn't it, by UAE regulation?
I am, and I would like to show you, Your Excellency, the documents that the documents of the claimant that give rise to this argument. So if I take, Your Excellency, to section section D, I beg your pardon, section D.
Page number?
D for Denmark, number 3, and page number 543.
Right.
It's taking me a little bit of time to reach there, because all of us are on the computer together, so I guess it's taking a while to load. Essentially, Your Excellency, this is the memorandum of association of an offshore company in Jebel Ali Free Zone. This is the document that provides the purpose of the company. And at 4.2, which is at page 543, you will see that the company shall not carry on business with persons resident in the UAE. It's an express prohibition. It shall not carry on at C, 4.2C, carry on banking business. And furthermore, the similar prohibition is in the
What is the sanction of this? I've seen this, I've read it. I spent last night looking at this document. What's the sanction against this?
Sanction against it is provided itself, and there will be an investigation, and there will be a further. From what I remember,
is it licensing a regulatory matter that related to JAFZA? I mean,
it is potentially a matter for the regulator of JAFZA, the registrar of the JAFZA, to whether to basically strike off the company from the register for breach of its licensing breaches, and it's for the registrar and the regulator effectively to look into it further, to have an investigation as to what this company is actually doing in having been incorporated in Jebel Ali with the and there are punishment and offences set out in Schedule 3 of the JAFZA regulations, which provide further censure and powers to the registrar when looking at particular breaches.
But what's the legal sanction against the contract that you're signing together? I understand. I mean, people breach the regulation. Even here in the DFC, by the way, we do have a contract, and some parties breach, let's say, their own regulatory framework, even here within the DIFC. It happens all the time. In many contracts, people go beyond their, I don't know, its role or the way you call it capacity, which I slightly find it a very harsh statement, a word to use. They go beyond their licensing, but then that render the contract null and void.
We say that, Your Excellency, that if a party does not have the license to do a particular business, they cannot undertake that business with the means that is required. They cannot undertake that business in the same way that a licensed entity can do so. There's a reason why a licensed entity is allowed to do so, for a variety of reasons. For example, under there are prescriptions in the UAE central banking regulations. Once you're a bank, how are you supposed to give loans as such? How are they supposed to be collateralized? Are they supposed to be collateralized at all? I mean, so within even DIFC, how you're supposed to be a banking financial services company, there are regulations around it. There are rules around it. So it cannot be anybody can wake up and say, yes, today I feel like being a bank and I'll enter into these agreements and charge, because DIFC laws allow interest to be charged on loan amounts. I can charge 100% loans or 50% loans. So there has to be some kind of structure and regulation that governs the credit agreements as such, which are issued in any jurisdiction, especially in UAE, which is very specific to how banking work is supposed to be undertaken. So we say that it does affect the very existence of whether a company can issue into a loan agreement, given the fact that it's prohibited to do it. So it's only prohibited to do it because it can't do it. It's a logical extension of what the prohibition is. So we say it should be given effect.
But does that mean anyone would deal with a company knowingly they are not licensed to do that? He would take their money and run away and said, well, but you're going beyond your license.
No, there's two parts to what you're saying, Your Excellency.
Yes.
The money, for example, under this agreement was given. So that if we say that it was given and we have received it, it will be unjust enrichment if we just say you were not supposed to give a loan agreement. We still receive the money, so we must return it back because for whatever reasons, basically this agreement was done, and they were not allowed to do this transaction, and money is returned. But the point being, the sanction of using that agreement by like a financial services and benefiting from the financial services company's licensing structure, which allows it to lend money on interest, that should not be allowed to a company which has no capacity to enter into such an agreement in the first place. That's what we say.
And if it's to be allowed, they should not be allowed to get interest more than the licensed institution that carry its business in the usual way.
We agree with that, and in essence, we say that they cannot create an unenforceable clause, a penalty clause, which essentially means that people will be paying interest at 150% of the principal.
And that's the excessive rate of interest that you're bringing into your secondary point. And
that's correct.
If it's said to be the IFC law, not UAE laws.
That's correct, Your Excellency. So essentially, what I've shown you, Your Excellency, if I take you to the JAFZA rules, which are at section I, number 11, and it's regulation 14, which is at page number 1481.
Yes, I got it.
So as you can see, the regulation 14, restriction on activities. This is identical what you see in the memorandum and what you see in the articles. The reason why this is in the articles, because it's a mandatory provision. So they just didn't come up with this. It is something they were supposed to follow. And it's express prohibition not to do any commercial activity. It says, if you see at 14A, they're not to directly carry out any commercial activity in the UAE. It's not a one-off commercial activity. It is a specific reason you go to a free zone to do certain things, and you stick to those certain things. And in this case, this is not what happened. And I will show during my cross-examination, Your Excellency, that this is not the only one-off thing they have done which contravenes their license. They have done a number of things which I will point out, which establish our point that this is a company which was going beyond its license, and it seems to be something they were doing without regulatory approval.
Well, Mr. Mato, you might show me they have done a lot of horrible things. against their licensing, JAVSA laws and regulation. But most importantly, you need to tell me what's the sanction this law applying the contract between these two parties has to do with.
Your Excellency, it's the point I was trying to address. My learned friend raised.
Maybe the sanction strike out the company from the record, maybe not allowing them to do business, but why that would be reflected in this case today? I mean, you know what I mean? That's very important. I will leave it for you now. I'm just putting. I'm throwing.
Your Excellency, I'm grateful for that.
Can be for today, can be for closing, can be any time. It's up to you, but it will be very important to me.
So, Your Excellency, my little friend raised the point that this was a one-off transaction they did, which was beyond their license. And I was addressing that point, Your Excellency, that this was not just one-off transaction. They've been doing other transactions which contravene their licenses. The effect of not following your license requirements, we argue that these regulations are statutory law when it comes to these companies, and they cannot contravene this. This has got some value that you can't do business, carry out commercial activity in UAE, can't do business with the residents of UAE, can't basically carry on a banking activity. So essentially, any agreement that derives from these prohibitions has to be considered null and void ab initio, because they never had the capacity to do any of these things within the jurisdiction that we are talking about. Yeah. So in essence, we say that in the first instance, the interest provisions and the agreement is not valid. But does it mean that loan amount should not be paid?
Have you seen Article 15 of that document?
Yes, Your Excellency. Would you like me to address Article 15, Your Excellency?
Yeah, go on.
Let me just come back to this Article 15. So Article 15, Your Excellency, is there a particular question about Article 15, Your Excellency, you have in mind?
Yeah. Of this JAVSA regulation.
Yes, a person acting under an express or implied authority of an offshore company may make or vary or discharge a contract or sign an instrument on behalf of an offshore company, the same manner if the contract may be made, vary or discharged, or the instrument signed by a natural person. But it still has to do with these contracts are contracts which are to be undertaken within the licensing framework of the company, not go beyond that. Mm-hmm. It does not permit them to enter into any. It's not an exception to Regulation 14. Regulation 14 is mandatory.
Mm-hmm. And I think 14.3 says the company should have, even if they want to go beyond that, they should take a permission of the.
Yeah, they must have an appropriate. I was going to come to that. 14.3 says if an offshore company wishes to conduct trade and other business in the zone or elsewhere in the UAE, it must obtain the appropriate license to conduct the trade or other business activity from the competent authorities pursuant to Part 17.
Yeah, okay, but I'm exploring this document. I'm trying to see where the sanction against the prohibitory conduct of companies.
This is the issue, Your Excellency. The issue is these companies were never designed to do these activities. So as such, there was no regulatory framework in Jabal Ali for there to be a banking facility, banking companies, precisely because there's not a regulator there to oversee banking activities. So essentially, the framework does not allow to address these things specifically. Your Excellency has to analyze the impact of it and assess whether a company with these prohibitions, with these express prohibitions, is allowed to carry out banking activities in a jurisdiction which it is prohibited to do in the first place. And it is not something which is there's an exception to. There's no exception to it either. So we say that this is relevant, it matters, and further, we would like to point out to you that the company is a UAE company in a free zone in UAE and not in DIFC or in any other jurisdiction for that matter. And if I take you to the central bank law, which is at section I number 9, and to Article 69 of that, 64 and 65 of that.
Yeah.
It's that page. So section I number 9, and it's page 1356.
1356?
Yes, Your Excellency.
Right, yes.
So, Your Excellency, Article 65, first of all, says the following activities shall be considered financial activities subject to central bank licensing and supervision in accordance with the provision of this decretal law. And subsection B says providing credit facilities of all types. Credit facilities are loan agreements as such, and different kinds of loan agreements. And if we go a provision up at Article 64, prohibition of carrying on or promoting financial activities without a license. It says that licensed financial activities may only be carried on in or form within the state in accordance with the provisions of this decretal law and the rules and regulations issued. So they must be only carried with license. These are licensed financial activities, Your Honor. So we say that this is a very serious activity, considered to be a serious activity within the country, and it requires a license. It requires precisely a license because banking is a specific kind of business which requires capital reserve ratios and so on and so forth, and collateralized means of doing business, there's a prescription of it since financial crisis. The UAE has entered into a sophisticated banking system which will prevent any kind of defaults of banks eventually. So that's the framework of how central bank regulates the companies doing business in banking sphere. We also say, Your Excellency, that our position is that Mr. Nirmal Kumar Sethi is the ultimate beneficial owner of the claimant. He controls the claimant. He's the directing mind of the claimant. And there's evidence that shows that he was using this for his personal purposes, this company. So it could be made, argument could be made that he was using the company as an alter ego of himself, essentially using, by way of this company, he was dishing out personal loans on interest, which is prohibited under UAE law. An individual lending money to another individual on interest. And we say that is an argument that has to be tested, and we will establish through cross-examination that this is a relevant factor to be included. DIFC law doesn't have any criminal provisions, so it must look at the UAE Federal Decree number 31, 2021, Article 458, which prohibits expressly this activity. Furthermore, Your Excellency, we have extensively in our skeleton argument set out legal provisions concerning unenforceability of a penalty. Now we say that UAE law, as directed to you by my learned friend, does not permit excessive interest, which is going to be unfair, unconscionable, and so on and so forth. And there is now case law from from the Supreme Court of the United Kingdom that we have adequately addressed in our skeleton argument, which shows that a interest provision which is unconscionable, extravagant, and oppressive to the primary interest that was the purpose of the interest, it has to be considered to be an unenforceable penalty, and it has to be disregarded when making a determination. We say that it is relevant to look at that in the present context. In the present context, the loan amount is 1.2 million. At the end of the whole loan amount, if the defendant was to pay the interest today, it would be nearly $2 million on a loan amount of 1.2 million. In no way could this be a reasonable commercial deal that any businessman could have entered into. So we say that this is an unenforceable penalty, Your Excellency. Furthermore, I would like to basically put it on record that the defendant is a resident of United Arab Emirates, and he is resident of Dubai. And it's relevant because under the articles and under the memorandum and under the regulation of JAFSA, the claimant is not allowed to do any business with the residents of UAE, carry out any financial commercial transactions, or any commercial transactions with residents of UAE. So we say that. Furthermore, I would like to point out one more point, make one more point, Your Honor, on the loan agreement. If you look at the loan agreement that we are talking about, which is at section E, number 1, and it's at number 556, page 556.
Yes.
In this loan agreement, the claimant calls itself the lender, like any bank would, and calls the defendant the borrower, then talks about the loan amount. And this was a document drafted and produced by the claimant. And then we have the first limb of the interest rate during the duration of the agreement, and then the default agreement, which becomes from a simple interest to a compound interest of 36%, which we say is a penalty. And it's the second page. It's a very unsophisticated agreement. It's a 2-page agreement for a loan of 1.3 million, which we say in any event is not enforceable, and it was signed by Mr. Sethi, Mr. Nirmal Kumar Sethi, who we say is indistinguishable from the claimant. So those are our opening remarks, Your Excellency. Unless you have questions for me, I will rest our opening remarks with that.
Thank you very much. Samato. Having done this opening statement, I think we will move to the witnesses. We do have Mr. Karim witnesses comes first. Is that right?
Yes, Your Honor.
Yes, Your Honor.
So Karim Mahmoud, you may call your first witness.
The first witness today is going to be Mr. Harsh Shah.
Good morning, Mr. Shah. Can you hear me?
Yes, ma'am. Good morning.
Good morning. Can you please confirm if you would be swearing or affirming today?
Swearing. Swearing what?
And do you have your holy book in front of you?
Yes, I have a Bhagavad Gita.
Okay, thank you. Please place your right hand on it and repeat after me.
Sure.
I swear by the Almighty God
I swear
by
by
the
Almighty
Almighty God
God, by
to,
the Almighty Man,
to say the truth,
to say the truth,
the whole truth,
whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Mr. Karim, you may introduce your witness, but you need to tell us first who's the person sitting next to the witness.
So our two witnesses are together. I think we can excuse Mr. Vinay from the room.
Okay, that would be good.
Is it possible, if my learned friend can get the camera near the witness, if possible?
And yeah, we can adjust that. Can you give us?
I need an assistant, sorry for this.
No problem. We have someone coming to adjust the zoom so that it's a little bit closer.
No worry.
Okay. Is it okay?
Yes. That's better, yes.
Thank you.
So, Your Honor, we have Mr. Harsh Shah, witness on behalf of the claimant. He's produced a witness statement, which he has in front of him. Mr. Harsh, do you have your witness statement in front of you?
Yeah, just a second. Yes, I have a witness statement.
And you confirm that this is your witness statement?
Yes, these are my witness statements.
Is this the first witness statement?
This is the first witness statement.
Okay.
This is the
Mr.
second
Matu,
one. Done.
We're coming in to adjust the camera. Your Honor, I believe we're all set. Mr. Matu, if I hand over to you, if you have any questions, Your Honor, if you're pleased with that.
Hello, Mr. Shah, you can confirm you have signed these two witness statements before you?
Sorry, sir, can you repeat? I didn't hear properly.
Is it you who have signed the witness statement before you?
Yes, sir, I have signed. My signature.
Mr. Mato, the witness is yours.
Thank you very much, Mr. Shah. I'll be asking you a few questions and then I'll let you leave in fairly short time. You're the finance manager of the claimant, correct?
Yes.
You also acted as an agent of Mr. Sethi and the claimant, correct?
No.
Can I take you to section D, number 3, page number 505?
505.
Just refer him to his witness statement directly.
No, I'm taking him to a document, Your Excellency.
Oh, I see. Another document. What's the reference again, Mr. Mato?
Yes, it's section D, number 3, page number 5.
505. Yes.
505, sorry, 505.
Okay.
So this is a judgment from UK court in a company which is related to the claimant, correct?
Yes. Sethi London Limited.
Just trying to load. You have a benefit of a bundle, but my computer is, because all of us are on the computer, is taking me a while. Just let me let the
Take your time, Mr. Mato, no rush.
Sorry, Your Honor. It's not coming up in my computer. It's taking there's a lag. So essentially, whilst I'm waiting for it to come up, if you look at paragraph 15, in paragraph 15, the judge has made an assessment and said that basically you also acted as an agent of Mr. Sethi and the claimant, correct?
Yes.
So do you disagree with what is said there?
No. I am not an independent agent of NSI. I mean, NS Investment. And this is the agency. What is written here, it is in the terms of particular transaction. I am not a regular agent.
So what is said, let's test this a bit. At the request of Mr. Sethi, prior to the conclusion of the formal written agreement on 2nd of July 2019, okay?
Yes.
You agree that there was an agreement entered, the loan agreement in Dubai is dated 2nd of July 2019.
Sorry, can you repeat, please?
The loan agreement is dated 2nd of July 2019, correct?
Yes.
So Mr. Sethi provided an undated check in the sum of 87.9 million to NSIL, okay?
Yes.
And then it says that in an email on 2nd of July 2019, Mr. Shah, as agent of Mr. Sethi, SLL and NSIL said as follows. So you have acted as an agent of Mr. Sethi and the claimant, correct?
For particular transaction, yes.
Mr. Nirmal Kumar Sethi is a director, secretary, and the shareholder of the claimant, correct?
Yes. He is one of the director.
That's why I said he's a director, secretary, and shareholder, correct?
Correct. And a shareholder.
Mr. Ajay Sethi, the defendant, you'll agree, is a resident of the UAE, correct?
Correct.
The claimant is not a bank or a financial institution, correct?
Yes, it is not.
The claimant is a JAVSA offshore free zone company, correct?
Yes.
So you would agree that the laws and regulations of JAVSA free zone apply to the claimant, correct?
Of course, yes.
So the claimant was only permitted to business approved under JAVSA rules, correct?
For business, yes.
And it was the only object of the company, based on the documents you must have seen that I referred, Your Excellency, to, was to carry on business specifically set out in your memorandum of association and articles of association, correct?
Yes. We undertake same businesses.
Which for the sake of the clarification is to carry on the business of general trading, owning properties as permitted by JAVSA, namely at the Palm Islands, Jumeirah Islands, so on and so forth. And it was precisely to do investments in shares and to purchase and sell real estate properties as approved by JAVSA rules, correct?
Correct. It is as per the memorandum.
So under the rules of the under the JAVSA rules and laws and regulations, and your incorporation documents, your constitutional documents, you were not permitted to do any business with the residents of UAE, correct?
Right.
Under JAVSA law, the claimant was not allowed to do any commercial activity in the UAE, correct?
I'm not familiar with the JAVSA law specifically. So if it is there, could be there, but I cannot comment much on it. Our lawyer, who is like much eligible for or knowledgeable for these particular provisions, he can brief you on this.
But as a finance manager, it will be correct to say that you would want to do things which are legally compliant, correct?
Yes, as a finance manager, we should know, but 100% knowledge of anything is like not practically possible.
as a finance manager, it's correct to say that you would have read the memorandum of association, correct?
Yes, memorandum I have seen.
So the memorandum of association expressly provides that you can't do banking business, commercial activity, correct?
Banking business, yes, it says.
And so under UAE law, under the JAFZA law, providing a loan agreement would be a banking activity, correct?
I am not sure about this.
But
The
is
definition
it
of business, definition of the provision, I'm not much eligible to answer that because I don't have much experience with that. But I can answer you on the facts of the cases.
the claimant does not have a banking license in the UAE, correct?
Sorry?
The claimant does not have a banking license in the UAE, correct?
No, it doesn't have.
The claimant is not, you just agreed with me that it's not allowed to carry out banking related activities in UAE, correct?
As per memorandum, yes, banking businesses are not allowed.
Given that the claimant does not have a valid banking license and it's not allowed to enter into loan agreements, which are banking agreements, with a and not allowed to work with, do business with UAE residents, you would agree with me that by entering into the loan agreement, you breach the memorandum, your constitutional agreements, and the law of JAFZA, correct?
I can't agree on this. Whatever we have done is based on the solicitor's advice, and our lawyer can throw the much light on this because what we have entered into a like once of transaction, and I don't know, I can't comment whether I agree or not. Because what I agree you may not agree, what you agree I may not agree.
So did your lawyers advise you that you can work with UAE residents? Is that correct to say that?
We can, if it is not a business, we can.
So that was the
And not
advice
our
you received
lawyer.
from your lawyers.
Sorry?
You state that you received advice from your lawyers you can do any business activity with UAE residents, correct?
And not business activity. Transaction we can do. It's a better one of transaction.
You agree that transaction is a business activity, correct?
No, it is not a business activity.
You would agree that transaction is a commercial activity, correct?
Could be, I don't know. I cannot be surely it is a commercial activity or not, but it is a transaction and it is done by the company.
So any engagement that the claimant does, would that not be a commercial activity?
If it is done by the corporate, it is called commercial activity.
So the loan agreement was done by the claimant. It is a commercial activity, isn't it?
I mean, yes, and what extent you are trying to say, I don't understand. But if any activity done by a corporate, which is called commercial activity, as per the finance manager, I know. Okay, if there are other provisions or other definition to this, our lawyer can assist you on this.
You carry out routinely business with other UAE residents as a company, isn't that right?
No, we don't do business with any resident in UAE.
Can I take you to section D? Sorry, section E.
Mm-hmm.
And to number 2.
Page number, sir?
I'm loading. Sorry, I'm very sorry. It's taking me a while, but it will be
558.
558. 558.
558. Sorry.
Yeah. Do you see this
Just
document?
a second. I'm coming to it. 558.
Yeah.
Okay.
This is a transaction concerning a company called Anamika, right?
Yes. Yes.
Do you see who are the parties in this transaction?
It is saying Omar Ali Hassan Laha,
And
NS Investment, Ziad Barakat. Yes, tell me, sir. I can see the parties.
the claimant, correct, right?
Yeah, this is one of the party. Yes, it is
Yes.
Mr. Omar, NS Investment is the claimant, and Mr. Ziad Barakat.
So if you go to the next page, you will see that Mr. Al Shihi is a UAE resident, correct?
Yes.
And then if you go to page 560, it will provide you that Mr. Barakat is also a UAE resident, correct?
Correct.
So you just told me that we have never done any other transaction with any other UAE resident. That's not right. That was not correct, right?
But then this is the investment in the shares. We have bought the shares in the company.
But according to the
this is not a transaction with the individual. This is what we see. This is not a transaction with the individual. This is a transaction for acquiring the shares in the company.
But this is a business you're doing as three partners in a company in which you're investing, and it's not a Jafza permitted activity.
I'm sorry, I'm 100% not confident on this, but to the best of my knowledge, this activity is permitted as per my memorandum, as per the Jafza, because we can invest into shares, we can invest into the particular companies approved by the Jafza, and this is not a transaction, this is the acquiring of the shares. My interpretation, your interpretation can be different.
Let's have a look at this. Yeah, as to what is the purpose of this? If you come further down, it says objectives of the company at Article 4.
Page number, sir?
It's 563.
563. I'm sorry, Mr. Mato, before we go further, it will be really helpful for me if you say any page number, because I'm not familiar with the sections or subsections.
Don't worry, it's one of my last few questions.
If you tell me the number, it will be easier for me. Sorry,
it's 563, page number 563.
Okay. Yes, sir, tell me.
So it says that the main objectives are to own and invest in any and all the funds and assets of the company, whether movable or immovable, or whether within or outside the UAE. Okay.
Okay.
If you want me, I can show you your objective purpose of the company from your memorandum.
Yes,
this
please.
goes beyond that. And you're entering specifically, your memorandum does not allow you to do business, carry out business activity in UAE, besides what is being carved out for you under the Jafza rules. So isn't that right that you were doing business beyond the permitted activity, beyond the loan agreement as well?
I totally disagree with you, because this is a memorandum of a company, Anamika Industrial Investment LLC, which is now named as Anamika Investment LLC. Okay, this is the memorandum of that company. I cannot compare that memorandum of a company where I am a shareholder or investor to be compared with my memorandum of NS Investment. I mean, my understanding doesn't allow me to do. Your understanding or your knowledge can be, which our lawyer can guide me. Yes, it is yes or no. I cannot say.
Mr. Shah, the facts speak for themselves. We have to agree to disagree, even though it's patently clear that
absolutely.
This is beyond the scope of your license activity. Your Honor, I have no further questions for the witness.
I have just a second, sir. I have.
Oh no, you didn't ask. You didn't ask, Mr. Shah. Sorry, Mr. Shah.
Please go ahead,
Yes,
Mr.
sir.
Shah. Sorry.
Are you answering any of the question?
Sorry, sir.
Are you answering any of the question being put to you before?
I mean, I was
Or
wrong
you
for something.
making comment?
No, I want to answer something to Mr. Salah. A continuation of the answer.
Please,
Go ahead.
go ahead.
Okay, so I'm not familiar with the sections and provisions. If you can take me to the memorandum of NS investment, the page number.
Yes, certainly. If you go to section D,
Page number given.
yeah, sorry, I will, Your Honor, because I worked through. If I take you to D, so page number 543.
543.
So you will see that it provides a the objective of the company, the permitted activities of the company.
Yes, sir. So it says to be like, I'm reading this one. Okay, what it says. The property Dubai World, Dubai Holding, or any other properties approved by the authority to be and act as a holding company. We are holding the shares in the Anamika investment to do the investment in the shares and purchase of the real estate and sell. So we are doing that activity.
But
I mean,
as approved by the JABZA rules.
Approved by JABZA rule, yes. So without, to the best of my knowledge as a finance manager, we cannot invest in any company in UAE or out of UAE unless and until we have got NOC from the JABZA.
And in the case of loan agreement, you had no NOC from JABZA, did you?
Sorry.
For the purposes of the loan agreement, you had no NOC from JABZA, did you?
No, we don't have NOC.
I have no further questions, Your Excellency.
It is not required. Thank you, sir.
Thank you, Mr. Shah. Mr. Karim, do you have anything to do back with your witness?
Yeah, I just have a few questions, Your Honor. Hopefully I'll get them done quickly.
Go on.
Mr. Hosh, do you advertise or solicit for loans? Or does NS Investment advertise or solicit for loans?
Sorry, Mr. Karim, if you can repeat, please.
Does the company, NS Investments, advertise or solicit for loans? Does it market a banking business? Does it market for loans?
No, we don't.
Okay, so do you have a credit risk department or a credit analysis department to assess loans?
No, don't.
Okay. In your opinion, does NS Investments carry on a banking business?
No.
Okay. Is NS Investments carrying on any business with Mr. Sethi?
No.
Thank you, Your Honor. Thank you, Mr. Shah. Your Honor, I have no further questions.
Thank you very much. Thank you very much, Mr. Shah. You may call the other witness, Mr. Payne.
Thank you, sir. Thank you.
Thank you, Your Honor.
Mr. Mato, are you still with us? Yes, I see you now.
Yes, Your Honor, I am here.
Morning, Your Honor. We have with us Mr. Vinay Sarana, who's a director of the claimant. Mr. Sarana, do you have in front of you your witness statement? This should be your fourth witness statement. Can you see? Do you have in front of you your witness statement, Vinay?
Sorry, Karim, could you repeat again?
I said, do you have in front of you your witness statement? Can you hear me clearly?
Yes, I have my witness statement in front of me.
And what is the title of that witness statement?
Mr. Karim, if we need to have him serve the oath first and then
Oh, yes. Sorry.
swear.
Apologies, Your Honor.
Shahla, you may go on.
Thank you. Mr. Vinay, can you please confirm your full name and occupation for the record?
I am Vinay Kamal Surana, and I am the director of NS Investments.
Thank you. And will you be affirming or swearing today?
I will be affirming the oath on Bhagavad Gita.
Do you have your holy book in front of you?
Yes, it is in front of me.
Okay, please place your right hand on it and repeat after me. I swear by the Almighty God
I swear by the Almighty God
to tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Thank you. Vinay, do you have your witness? You confirmed you have your witness statement in front of you. Is that correct?
Yes.
Okay, and you confirm that this is your witness statement?
Yes, I confirm this is my witness statement.
And you have signed this witness statement? That is your signature on this witness statement?
Yes, it is my signature on the witness statement.
Can you confirm the title of the witness statement?
The title of the witness statement is in the Dubai International Financial Court. So between
Just the
NS
name of the document, Vinay.
Sorry.
The name of the document. Is it what is the number of the witness statement? Is it the fourth witness statement you hold in front of you?
Yes, it is the fourth witness statement of Vinay Kamal Kumar Surana.
Thank you. Your Honor, I hand over to my learned friend.
Thank you very much. Mr. Mato.
Mr. Surana, thank you so much for making yourself available for today. We're very grateful for your presence. You are the director of the claimant, correct?
Absolutely correct.
You were very much involved in setting up the business of the claimant in Jebel Ali, correct?
Yes.
In fact, you signed on behalf of all the directors rather shareholders of the claimant, correct?
Yes, correct.
You would agree that Mrs. Sethi is the defendant is a resident of the United Arab Emirates, correct?
Yes, that's what is there in the papers.
Is that what you consider to be correct?
Yeah.
You would agree that claimant is not a financial institution or a bank, correct?
Yes.
And you'll agree that claimant is a JAFZA incorporated offshore free zone company, correct? Yeah?
That's correct.
You would agree that claimant is subject to the statutory laws and regulations of Jebel Ali Free Zone, correct?
Yes. Yes.
You would agree that claimant was permitted to do business only approved under the JAFZA rules and under your constitutional documents, correct?
Yes.
So you would agree that you must have heard from my cross-examination with your colleague and in my opening statement that the permitted purpose of your company and the activity that the company was involved is set out in the memorandum, correct?
Yes, it is there. And can you please repeat your question?
My question is, the permitted activity of the claimant is set out in the constitutional documents and regulations of JAFZA, correct?
Yes.
You would agree that there was a narrow set of activities that the claimant was allowed to do under its JAFZA license, correct?
Yes, whatever is mentioned in the memorandum, that is correct, but it's not part of my witness statement. So what the memorandum says, I agree with that.
But memorandum has been signed by you,
Yeah,
Mr. Surana, isn't that right?
And that's absolutely right. And the memorandum was signed on a certain date. If you want to refer to exactly to the memorandum, I can say yes.
Okay, for the sake of your confirmation, I would want to basically put the memorandum to you. The memorandum that I am looking at is at section D, number 3543.
Okay.
Okay. You might want to have a look at it in documents before you.
So I only have my witness statement in front of me. So if you want to share the memorandum in front of me, I'm happy to confirm that.
I think my learned friend must have provided you with a set of documents for today's cross-examination.
Yeah, Your Honor, we'll have, they're there in the room. We can have someone assist to direct the witness to the exact reference.
Okay. Page number which one?
543.
543. Just a second. Yes. Yes, sir. Please go ahead.
So you would agree that the permitted activities of are provided in the memorandum, namely the object of the company is to carry on business or general trading, owning properties as permitted, so on and so forth. You see that clause?
Yes, absolutely. I can see that. Yes.
And as the director of the claimant, it's correct to state that you were aware of the prohibitions and the general direction, the general regulations of JAPSA, correct?
Yes.
You were aware what you were allowed to do under the JAPSA rules and under constitutional documents, correct?
Yes.
So under the Articles of Association and Memorandum, the company is not allowed to do any business with residents of UAE, correct?
Yes, it is correct. Whatever is mentioned in the memorandum, we agree to that.
I understand. I just want to know for the sake of His Excellency's understanding that you were aware of this.
Yes, 100%.
You further agree that you were not allowed to do any commercial activity in the UAE, correct?
Yes, the memorandum says that, and we have agreed to it.
You were not allowed to carry out any banking activities or banking business, correct?
Yes, and we have not.
The question I've asked you that you were not allowed to do that, correct?
Sorry?
You were
Can you
not
come
allowed to
back?
do the banking business, correct?
Yes.
A credit agreement is a contract between a borrower and a lender that documents all the terms of a loan, right?
A credit agreement, sorry?
A credit agreement is a contract between a borrower and a lender that documents all the terms of a loan, correct?
Yes.
So under UAE law, providing a bank loan is considered to be a commercial activity, correct?
So for that, I think I'm not a lawyer to tell you exactly what it is. And I think our lawyer can answer on that point, is the best person to answer on that. I can reiterate the facts of what I have mentioned in my
I understand.
witness
I
statement.
understand. Can I
Whatever
just stop
you
you
want,
there?
I'm happy, from the starting on how the loan was taken, why the loan was
Sorry,
taken.
it's my prerogative to ask you
Absolutely.
questions. You
No
cannot tell
problem.
me what questions to ask you, Mrs. Surana.
Okay.
So please
Okay.
leave that to me.
Okay.
Issuing of loan agreement is a commercial activity, correct?
Yes. That again has to be answered by my lawyer. I can because this is not something which I am 100% aware of what the law
You
says.
did answer. You did answer.
You
did
answered the question.
Mr. Amar. Go on, Mr. Madhani.
So I was just comprehending of what exactly he was asking, and then I have responded to it, Your Honor.
So you do not agree that entering into a agreement is a commercial activity?
No, it is again the way This was a short-term loan which was provided, and the basis of the short-term loan was again.
Sorry, can I just stop you there, Mr. Surana? It's just a
Mr.
simple
Rana,
question.
I mean, if you allow me, Mr. Mato, Mr. Rana, Mr. Mato asking you, I mean, to get into a credit or loan agreement with interest, from your point of view, from your company point of view, would that consider to be a commercial activity with a UAE person outside your free zone? Is that right?
Sir, again, this may be termed as, I'm not 100% sure, but may be termed as commercial activity. But this was one-off case. It was not like a commercial, which means that it is a recurring process. But yes, on one-off case, yes, this loan agreement was done by us.
Your Excellency, can I proceed?
Yes, please.
The claimant does not have a banking license in UAE, JAFZA, or DIFC, correct?
No, we don't have a banking license.
And as you have agreed with me, claimant is not allowed to do any banking related activities in the UAE, correct?
No, and we have not done.
Given that the claimant does not have a banking license, it's not allowed to enter into a loan agreement under the JAFZA rules, correct?
That again, I think our lawyer is the right person to answer on that. We have signed the loan agreement, but yes, what the law says, I think Kareem has already put the points in front of the honorable.
Okay.
You know, we follow that. You know, whatever the points which have come from Kareem. Yeah.
As a director, are you aware of the JAFZA rules?
Yes, I'm aware of the JAFZA rules, the memorandum, absolutely.
So the JAFZA rules expressly state that you're not allowed to do banking business. You're not allowed to do any kind of credit activities, which is banking business. You're not allowed to do any business with UAE residents, carry out commercial activity, correct?
Sir, again, the same thing I want to answer, that it has been contested by our lawyer on the same point, and I think the articles and everything he has defined.
I have to stop you there for a second.
Okay.
Are you contesting the fact that the defendant is a UAE resident?
Who is Mr. Ajay Sethi is a UAE resident, you mean?
Yes, are you contesting that?
No, that we agree that he is a UAE resident.
So the rules expressly state that you can't do any business with a UAE resident, correct?
Sir, I have already, answered to you on the same thing, that this is, again, for the lawyer, our lawyer to answer this question.
Your
I
Excellency,
can tell you what
I
is
have to
in the
ask you to
witness
intervene
statement.
here. This is not a legal question. It's a factual question. I have to move on, but I can see that the witness is deliberately not answering a question, which is very simple. There's no legal point here. It's a factual point, and the claimant and the witness has admitted that he's aware of the JAFZA rules as a director, and I don't think he requires a lawyer to interpret to him what regulations state.
Your Excellency, may I suggest that the fact that
Sorry,
the defendant is
my little friend, no, this is a cross-examination. This is not a time to, you'll get your time to rebut. I think that will be appropriate for you to intervene at that point.
Right, Mr. Mato.
So I put to you, Mr. Surana, that under JAFZA law, you were prohibited from doing banking business, and it was not permissible for you to enter into the loan agreement with Mr. Sethi. Isn't that right?
No.
So your position is that you were allowed to do banking business under JAFZA law, correct?
No, but there were two parts of the question. For the banking business, I've said no. For the loan agreement, I have said yes. Yes, on the basis of where we have our auditors who has confirmed, and then we had went ahead with the loan agreement.
So you decided on the basis of your auditor to enter into the loan agreement. Your auditor advised you to enter into the loan agreement, correct?
Yes, we have entered in the loan agreement. Yes.
So your auditors told you will not be breaching any laws and regulations for entering into the loan agreement, correct?
You see, it was in 2019. I don't remember exactly, but yes, we had internally had a meeting with the board of directors, and we had decided on the loan agreement, and we had signed the loan agreement.
So it was done with careful consideration, Mr. Surana, correct?
Absolutely, 100%, sir. We have signed the agreement. We have stood by the agreement. So we 100% agree to the agreement.
And knowing full well your prohibitions under the JAFZA rules and your constitutional documents, you still entered into the loan agreement, correct?
No, we don't agree with the prohibitions, what you are mentioning. We entered into the agreement, considering it right and absolutely lawful, and we have entered into the agreement.
Knowing full well, having full understanding of the regulations, you reached a conclusion.
Yeah, 100%.
Let me just complete my question. So knowing full well the prohibitions in the rules and in your memorandum and your articles, you still entered into the loan agreement with the view that you're allowed to do this, correct?
Yes, sir. We have signed the agreement, and we agree by it.
Sorry, Your Honor, I'm going to ask the same question again because it's an important question.
He answered the question before. He said, we think it's lawful. That's why we signed it.
Okay. So the point being, I just want to put it to the witness that it's his, according to them, the JAFZA law and their memorandum and articles allow them to enter into a loan agreement. Is that what you're saying?
Yes, we have gone into the loan agreement, considering all the points, and we have signed it, so we agree by it.
Okay. You would agree that you were not allowed to do any commercial activity, which is not accordance with JAFZA rules and regulations, correct?
Yes, whatever is by the memorandum, we stand by that.
Okay. Now, I've just got a few questions, Your Honor. Not that many. So, Mr. Surana, you would agree that Mrs. Sethia, Mr. Nirmal Kumar Sethia, is the ultimate beneficial owner of the claimant, correct?
No, on what basis are you saying so?
I will refresh your memory. Can I take you to document section D?
Okay.
And to page.
Well, I can tell you he's a minority shareholder.
But sorry, can I, Mr. Surana,
okay,
if you
yes, please. Okay.
If you gave me the courtesy to ask the question, then I will give you the full opportunity to answer.
Okay, please.
If I take you to page 482.
482. Just a second. Yeah.
Let me know when you're there. Okay. Sorry, my computer is not as efficient as your bundle. So 482 is a side agreement which was prepared by Altamini, okay, by the claimant's lawyers.
Okay.
Okay. And if I take you to 482, it says this is the drafting of your lawyers, Mr. Surana. It says that at recital C, for the avoidance of any doubt, the ultimate beneficial owner of SLL and NSIL is NKS. NKS being Mr. Nirmal Kumar Sethia, correct?
Yes, that is correct.
Is that what it says?
You see, but there are shareholders on that.
I
And this is
understand.
again, which is again on the memorandum. So I think that we stick, because I have not gone through this document. So at this stage, I can't say exactly after referring just one line, but the fact of the matter is, when it comes to NS Investment, I am the director on NS Investment. Mr. Nirmal Sethia is 10% shareholder. Ms. Richa Sethia is 45% shareholder. Mr. Puru Sethia is 45% shareholders, and the decisions are taken by the board.
Mr. Surana, all I wanted to seek a confirmation is this what your document says there?
No, but
sorry, Mr. Surana, please, you cannot look at your phone during your.
No, I'm just.
This is very inappropriate. This is inappropriate. You must not look at your phone, please. Please turn it off. You should have turned it off at the beginning of your testimony. This is highly inappropriate.
That's right, Mr. Mato.
Okay. So essentially, my point. I put my question. It's the recital is there.
Mr. Mato, let me clarify. Even the document you're referring to the witness, he just said he haven't gone through it all, so he can confirm your question. But I can see this is even unsigned document, isn't it? If you can see toward the end of it.
It was a document, Your Honor, for your context, provided by the claimant and its sister company and Mr. Nirmal Kumar Sethia to the defendant and defendant's wife to sign, and they refused to sign it. So that's the history of this document. It was prepared and produced and provided for signing to the defendant.
And why it's relevant to this case?
It's just to state that, you know, how important Mr. Sethia is to the claimant. We say that it's one and the same thing. Mr. Sethia and the claimant are the same thing. So essentially, Mr. Sethia is using this company for his personal reasons as an individual. But essentially, there's no difference between Mr. Sethia and the claimant. That's our point.
I don't think so.
Sorry, that's not. I was addressing Your Excellency.
Sorry. So,
Mr. Mato, your next question.
Yeah. So my question is, so Mr. Nirmal Kumar Sethia is a director, secretary, a director, secretary, and a shareholder of the claimant, correct?
yes.
So Mr. Nirmal Kumar Sethia is the controller of the claimant, correct?
No.
He's okay. Let me refresh your memory on this. Let me take you to page number 500 of this bundle. For your sake, Your Excellency, we are still in number 3, section D, page 500. This is a judgment, Your Excellency, for your benefit of Mr. Andrew Hockhauser, QC, in a matter which was related to this matter in London. And at page 500, Mr. Hockhauser has summarized the position of the parties in this, in which he says, parties, SLL is an English company. If I go further down to the last sentence, it says, Mr. Sethia, who is Mr. Nirmal Kumar Sethia, is also the director and controller of NS Investments Limited, a company based in the UAE. You see that? Mr. Surana, you see that?
No, sir, but this is a statement which someone else is making. I go by the memorandum of the company of NS Investments, and I know who the shareholders are. I know who the board of directors are. Anyone can write anything. It doesn't mean that it changes the board structure. The board structure is in front of you.
I'm asking you, it's a simple question.
I, as a board of director, I can confirm you, it is a board, and every person
has got not allowing me to intervene.
No, but if you ask me a question, at least let me allow me to answer that.
I am not asking you that question. I'm asking you.
You pull out any document and you tell me that what is there in the document, all of a surprise, is then I have to think and I have to go back to the memorandum.
Your
Mr. Rana, this is a judgment of English court. This is a judgment of English court.
This document was actually produced by the claimant and by us. So both sides have. I mean,
Wait, Mr. Mato, you didn't
Your
expect a
Honor,
witness to be prepared
Your
as a
Honor,
lawyer.
can I make a special request? It's
No, no,
been 3
wait,
years.
just wait, ma'am. Mr. Mato, well, I don't know if you will call it like judge finding as to a dictum, or it was that far. I mean,
what I'm saying, Your Honor, is it's a uncontroversial statement by the judge, which has never been
well, it's not
contested.
about controversial, if not controversial. If it's a dictum, then we can.
So, Your Excellency, I just want to make a small point on this. The way, just like DIFC in English courts, before entering into a judgment, a draft judgment is sent to the parties for correction purposes. If there's a factual inaccuracy in the judgment. So this has been validated by SLL, which has got the same beneficial owner, shareholder, Mr. Sethi, as NSIL. So we are just trying to put the same point to the claimant's witness that the claimant has.
Well, to be so, the witness says, from my record, from my papers, the situation is different.
I accept Your Excellency's point, and I'll move on. Isn't it correct that the claimant was used by Mr. Sethi as a means of doing personal business, and in fact engage in personal loans, provide personal loans on interest to the defendant?
No.
Can I take you to same bundle, same? It's the same judgment, paragraph 26 of the judgment. If I take you there to page 510.
Okay.
If I take you to paragraph 26.
That judgment about another loan, isn't it, Mr. Mato? First of all, I mean,
I'm just trying to show to the witness that Mr. Sethi has admitted to using his companies for his personal purposes. So if I take you to the paragraph 26, Mr. Surana, it says that on 1st March, NSIL, the claimant, issued a claim in the Dubai Commercial Court of first instance for judgment on the check. On the first instance, pleading the commercial proceedings, NSIL presented matters very differently from the evidence before me. It was said that it was NSIL that had loaned Mr. Sethi the money. It was a personal loan of 7.9 million, not a commercial loan for 4 million. So it has admitted to using a company structure for a personal loan here, correct? That's the finding of Mr. Justin Hockhauser, correct?
Sir, I'm not clear about it, because again, it refers to a different agreement, and I'm not sure, so I would like to pass this. What exactly you're saying, I'm not clear.
But on the basis of this finding, you would agree with me that it's the NSIL, the claimant, pleaded in Dubai court, in onshore court, that Mr. Sethi was using a personal loan, not a commercial loan of 4 million under the London loan agreement, correct?
No, you see, there were two loan agreements, which was one was UK. So I think there's a confusion which you're trying to create, and I'm not clear what you are. So I'm not clear if I'm not explicitly clear of what exactly you want to know from me, and the verdict of that case has already been out.
I'm not talking about the verdict.
It's a prolonged 3 years old case. 3 or 4
years.
Mr.
Surana,
Sir,
the claimant is seeking a judgment.
If you're asking me a question, please allow me to speak so you can understand me better.
Mr. Rana. Speak, Mr.
Sir,
Rana.
I can speak on what the witness statement is. You're asking me beyond that. Yes, if I have knowledge, I will share with you. But all of a sudden you tell me refer to this page and I'm not so clear. So I can say I'm not clear of what exactly you want to express here.
And is
Mr.
Ensil
Surana,
is not your company, isn't it? Ensil
Sorry?
is not your company.
that is the claimant, Your Honor.
NSIL.
Yes, Nirmal Sethi Investment Limited, Jabal Ali Company.
I say it's the same company, yes.
Mr. Surana, I would like to remind you, because you've raised this point, you represent the claimant here. It's not for us to have told you what to prepare for today. These are the documents that the claimant is relying on as well. They have submitted them in evidence in this case. So you're supposed to know what is in evidence. And you're trying to seek a judgment of a substantial amount of money based on this evidence. So it's not for me to tell you what to have prepared for today.
Okay,
You would
sir,
agree with
as
me.
you say.
You would
repeat the
agree with
question
me.
again for him?
Yes.
Sorry, sir.
The question, I'll repeat my question. You would agree that there is, based on what I've read to you, that there's been a admission by the claimant that Mr. Sethi was using corporate structure in London to advance personal loans by way of company, correct?
Sir, this has no relation to the loan agreement here. That was a separate loan agreement, and this is a separate loan agreement.
Okay,
So
Your
this
Honor,
has
I'm going
nothing
to
do-
move on because he doesn't want to answer the question. I just want to, for the sake of record, I put the question to him, and the witness did not answer the question. You would agree with me, for the purposes of the loan agreement in question in this proceedings, there's no difference between Mr. Nirmal Kumar Sethi and the claimant. They are one and the same thing, correct?
No, I disagree with you.
You would agree that in 2019, commercial lenders in UAE were willing to loan Mr. Sethi £6 million to buy properties in the UK at around 4-5% interest, correct?
I am not aware of this.
Can I take you to D1? If this is exhibit of Mr. Shah, your colleague. Take you to page 250.
250.
Yeah. Sorry, Your Honor. It's my last question, so not to steal Mr. Surana's thunder.
Yes, I'm at 250.
You see,
Okay.
it's a term sheet from Standard Chartered, right?
Yes, it's a term sheet from Standard Chartered. Yes.
It's for a loan facility of 6 million, right?
Yes, it says 6 GBP 6 million to be precise.
6 million pounds sterling, right?
Yeah.
And it's around the same time as the loan agreement was signed, right?
Now, I don't know. There is no
If
signature
I tell
on
you to
this
look at the
document.
date of this term sheet, what does it say?
I can't see the date on this.
I'm talking for my memory, so I'm waiting for my document to come up. So if you give me a second, I'll point you to the date. It says July 2019, Mr. Surana. Do you see that? I'm talking from my memory.
Okay, it is, yes. Draw date estimated to be July 2019.
Yes. So you'd agree that this is around the same time as loan agreement, correct?
Yes, it is. The dates are there. So what's there to disagree? July 2019. Yes.
I'm just asking for your confirmation.
Yes, to be precise, there is no date. So July could be any date in July.
Okay. You generally say this was near the date of the loan agreement, correct?
So I don't know, because the loan agreement was on 3rd of July. And when you say July 2019, when we are specific, then we should be specific here as well.
Okay. It was some day in July 2019, correct?
Yeah. Okay. Yes. If you say so, yes, the document says so. No problem.
I'm not saying it. The document is saying that.
Yeah, absolutely. Absolutely.
Could be 3rd of July.
Okay.
True.
Your Honor, your word is our command. interest provision, it says 2.10% above the bank's variable or fixed lending rate.
Yes, the document says so.
So take it from me, it was around between 2 to 3% in 2019, which takes us to around 5% mark of interest for a 6 million GBP finance facility. You agree with that? I mean, that's what the document says, correct?
You see, the document says, but I don't see any signature on the document.
It's an offer for finance from. I'm not saying that whether this agreement was entered. This was what the private bank of Standard Chartered was willing to lend to our client.
At this point, if you're referring to this document, I can see the facts and I can confirm, yes, this is the fact. But what is the relevance of this document?
Mr. Surana, this is first of all claimant's document.
Okay.
It's your colleague has submitted this as part of evidence. Okay. Okay. So this is your documents I'm referring to. It's not my document I'm referring to as such. Okay. Secondly, would you agree that in July our client was getting financial facility, a bank loan of 6 million, a credit agreement of 6 million pounds, which is nearly about $10 million, give or take a couple of $100,000 at that time for 5.5%. That was the reasonable commercial lending rate at that time. Isn't that correct?
No, I would disagree because I don't know the facts of the documents, whether what collaterals was asked, what was the term sheet of this document 100%. So it wouldn't be right to just looking at this and saying that this is the interest rate. On what basis?
But I'm saying generally there was credit available for 5% at that time. Isn't that right?
I have no idea because I'm not a banker. We don't do banking activity. So we have no idea that what was prevailing in those times. We have never. So if the document says so, and if you want me to read out what the document says so, I can confirm on the document.
You're not a banker, but you still entered into a lending agreement on interest with in London with a sister company and with the claimant in Dubai.
Absolutely, sir. If Your Honor, if you allow me, then I can highlight you one very important aspect is on what basis the loan agreement was given. It was in good faith, and there are various emails written by
Your Honor,
Mr.
this is not my question.
Please. Yeah, I see. I'm aware of the background. Yeah, Mr.
Please, Mr. Surana, if you can. My last question now to you is that I put to you that you very well knew that you were not allowed to do banking business in UAE. You were not allowed to do banking business or any business or commercial activity in the UAE. And importantly, you were not allowed to do any business with a UAE resident, i.e. Mr. Ajay Sethi, but you still disregarded all the laws and regulations and went ahead and did all that. Isn't that right?
I disagree.
I have no further questions, Your Honor. That's all I have to say.
Thank you, Your Honor. Mr. Surana, does NS Investments advertise or promote offering loans to people?
Not at all, sir.
Do you have a credit risk or a credit risk department to analyze loans?
No, sir, we don't give loans, so there's no credit risk department.
And loans aren't part of your normal business?
No, sir.
Okay. In your opinion, does NS Investments behave like a bank?
Sorry, does NS Investments
behave like a bank or promote itself as a bank?
Not at all, sir.
Okay. Mr. Surana, did you approach the defendant to offer him a loan?
Did we approach Ajay Sethi for loan?
Correct.
No, not at all. He has approached us at several occasions, and all the exhibits on what basis the loan was given is clearly been stated. And at the same time, in the various, we had even offered him a settlement plan after the default, where he has agreed on the interest rate on the legal fees, which is all documented, which he said that, yes, I'm willing to pay. So it is all in black and white, sir.
Thank you, Mr. Sarna. No further questions, Your Honor.
Thank you so much, sir.
Thank you, Mr.
Thank you, Your
Thank you very
Honor.
much.
Very grateful to you. Thank you, Mr. Saleh.
Thank you, Mr. Surana. Very grateful for your attendance today.
Thank you, Vinay.
Well, that's leave us to deal with your witness, Mr. Mato. I'm very good to go on with it, unless any of you wants to take a break.
Should we take a 5-minute break, Your Honor? My lungs are a bit heavy.
I would agree to that, Your Honor. I would also suggest we take a bit of a break.
Then let's make it 10. We'll come back sharply 12 Dubai time.
I'm very grateful, Your Honor. Thank you.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, Your Honor.
Your Excellency, we have no questions for Mr. Sethi, so we're happy to proceed with. I think we have scheduled. We've gone over our schedule. We have a scheduled break before closing. We don't have any questions for Mr. Sethi, so unless Your Honor has any questions for him, we don't have any need to read them.
You're waiving your right to cross-examine Mr. Sethi.
That's correct, Your Honor.
And we will spare Mr. Sethi's statement.
Okay. What are the grateful for my learned friend's confirmation. Your Excellency, how should we proceed? Should we take a further break for an hour and then reconvene for the closing submissions, or what do you direct, Your Excellency?
I see. Are you ready for a closing submission now, or you want to break for some times? Or I thought also I think you have alerted me during the pre-trial review. You might rely on maybe a written submission, or am I wrong with that?
We are entirely in your hands, Your Excellency. I would like my learned friend confirm on his behalf if Your Excellency would be benefited from a short written closing submissions instead of oral. Maybe with the benefit of having a transcript also of the hearing. We are open to that. In fact, we think it might be a good idea to have a short, maybe 5-6 page closing submissions at the most within a week's time. By today's 19th, we can submit them by 26th. I don't know what my learned friend thinks about that, but I think that might be actually, or maybe.
No,
by 30th,
if I would refer it, I will give it to you like by maybe 1st of July or 1st or 2nd of July.
I think because of Eid, Your Excellency, maybe 3rd of July might be better. 3rd of July.
3rd of July, yeah.
Your Honor, would you be opposed to just having oral submissions, a quick oral closing submission this afternoon, or is it your preference to have closing?
I'm not opposing, but I would really like today. What I hear very interesting things about related to the signing of the contract which is raised by Mr. Mato, whether the claimant has the capacity to sign this contract at all, based in the DFC laws or non-DFC laws. I think that was a bit interesting, and I would love to hear from him. I would love him to further in that kind of argument. And for you, for sure, I mean, Mr. Mahmoud, to reply to that issue. And then, as I said, if it's not capacity issue with the contract, and then if it said the claimant is gone beyond their trade license and things, and what is the sanction if that? Can the sanction be as that the contract is really null and void to that extent, or if you're going to cover this point, whether now or later, but I'm happy to hear you today for short time, and then
Your Excellency.
But I usually prefer like one set of submission. You know what I mean?
I would
divided into-
think, given what you have just said, Your Excellency, for the benefit of a reasoned judgment also, it might be helpful for you to have a short written closing from both of us.
But I won't confiscate your right, I mean, to speak or to present, I mean, to deliver oral submission too. I mean, I would see if Mr. Karim, because that the usual situation is an oral submission unless parties, I mean, let's go that and prefer to write or agree to write a written submission instead of oral. Mr. Mahmoud?
You know, this issue of capacity would be addressed in any event, Your Honor, whether in oral or in written. So I'd like to take instructions first on deciding to go to written. My only instructions now are to have oral, so oral submissions. So perhaps we can take a short break. I'll get instructions, or we can reconvene at 1, as the court prefers.
What do you think, Ms. Maro?
Our preference would be short written submissions, Your Excellency, because in that way,
And no oral submission.
no oral submission, because that's what modern litigation. Our view is also in modern litigation. It's common to have written submissions. Now that we have had benefit of evidence and we've had an oral, it might be useful for us to look at the transcript and then apply the transcript, whatever was given by way of evidence, and address, make short submissions on each of the points of capacity.
I would tell you what's in Mr. Mahmoud's mind. This is a case from his point of view, it's dragged for the 3rd year on the litigation, and he just wants to close the submission by today. He thinks he's ready to deliver, and he wants the judgment the soonest. That's what is in his mind. I mean, I'm telling you that what he thinks. And even from the overriding objectives, I mean, we have to protect this time. We have to shorten the length of a proceeding at the end of the day. You mean?
I'm entirely for efficiency, and if Your Excellency gives us even a week to prepare this, we are okay before Eid to give you to agree to submitting a short 6-page written submissions for closing by 26, or if that's okay with my learned friend and his client. So my instructions are, which I had sought, would be to fully engage by way of written submissions our closing position.
Your Honor, you know, my preference, the claimant's preference, would be just to finish this today. You know, we can address the issues of capacity this afternoon. We've had the benefit of hearing the witnesses. I don't think this matter is overly complicated. I also don't want to be held to a particular length of written submissions. I think this is something that we could deal with in a relatively short closing, which was envisaged, you know, prior to this hearing.
Well, see, if you remind me, unless I have given you direction during the pre-trial review, we would rely on written submission, then I think I would follow what Mr. Mahmoud saying. We will do the oral submission, but we will give you a short break. We will recombine at 1 o'clock, and then we start.
We're entirely in your hands. If Your Excellency thinks oral submissions are going to be beneficial for the parties, we will not object to it, Your Excellency. We will do what you please, Your Excellency.
An oral submission, we start in 1 hour from now.
Should we reconvene at 1:10, Your Excellency?
Yeah, 1:10. Yes, it will be 1:10. Mr. Mahmoud will go first, and then Mr. Mato will be second.
Very well, Your Excellency.
Thank you, Your Excellency.
Good afternoon, Mr. Mato.
Your Excellency, thank you for the break. It was much needed.
Agreed. Good afternoon, Your Excellency.
you're here as a journalist.
Your volume is a bit low, Your Excellency.
From my side or your side? Maybe your speaker. Can you check your speaker? I'm not sure.
Oh, it's perfect now. Sorry.
Mahmoud, do you hear me?
I can hear you. I've also increased my speaker volume.
Lovely. So we have, I think, how long do you think you're gonna, Mahmoud?
10 minutes, maybe 10 to 15 to be safe.
Oh, that's fine. I thought it could be more even than that.
Well, I underestimated last time, so even if we say 20,
yeah, you see,
hopefully it won't be too much.
I thought about half an hour each or something.
I will certainly keep it within half an hour.
Great. So, please.
Thank you, Your Honor. Well, just one quick point addressing the issue of Caterpillar. The license now, we've looked at it. It's a non-regulated entity, but it appears at some point it may have been regulated. So I just wanted to correct that inadvertent confirmation at that time. So, Your Honor, it is generally an established principle that there's. Sorry, Your Honor, I can't hear you.
I can't hear you.
Okay, good. Generally, Your Honor, I'd like to start with the fact that there's this general freedom to contract. Unless there's a specific provision telling us that a certain activity or action shouldn't be done, parties are free to agree to do it. Under DIFC law, this allows the claimant to enforce the loan agreement. The claimant does not deny that it doesn't have a banking license. The claimant is not attempting to take on the business of a bank. It doesn't have the ability, nor does it wish to. Right? This was established long before and confirmed by the witnesses as well. They're not pretending to be a bank. They're not advertising as a bank. They're not soliciting clients. They're not taking on this activity on a daily or even regular basis. So in this situation, it was the defendant who approached the claimant multiple times for a loan, and finally the claimant agreed. We believe, Your Honor, that nothing precludes the claimant from doing so, and nothing has been evidenced that prevents this loan from taking place. Now, this issue of whether this loan constitutes regular banking activity is something that was discussed at length. We argue that it does not constitute a regular business activity or the carrying on of a business activity as it's referenced in the JAVSA regulations, right? The claimant is not carrying on this business. Sorry, Your Honor, you're on mute.
I'm not talking, actually.
Oh, okay. So there is freedom to contract unless there's a specific provision against it. This is why, for example, the DIFC court can charge for photocopies, or my law firm can sell the car that's used for by the PRO, even though it's not provided for specifically in the license. Now, my law firm can't import vehicles, right? Because that's a specific activity that it's prevented from doing so. But generally, you're allowed to do something unless there's something preventing you. We also argue, Your Honor, that if this was seen as an issue by the regulator, which we argue it's not, the regulator would be the best place to deal with it. They have the authority to impose fines, which they regularly do, as well as strike off companies. Our position, Your Honor, is that it's not for the court to assume what the regulator would think of a company providing a loan. Now, as for the issue of capacity, the claimant had legal capacity to enter these contracts. I think the term capacity that was being used by my learned friend was being stretched quite broadly. All right, the loan agreement was signed by an authorized representative of the claimant. We saw that Article 15 of the JAVSA regulations provides a representative of the entity to enter into contracts. And so this, Your Honor, is the only question that the court needs to have answered if there's any concern about capacity. Was there capacity to enter into the contract? Yes, there was. If there was an issue with the nature of the transaction being a violation of JAVSA regulations or any regulator's regulations, it's an issue to be taken up and determined by the regulator. Again, the court is being asked to do more than it needs to. It's being asked by the defendant to step in the shoes of a regulator and to determine non-DIFC regulations or violations of these non-DIFC regulations. Again, all these regulators have tools at their disposal, including fines and sanctions and striking off if they were to determine that there is a breach of their own regulations. In addition, Your Honor, there's no concept of rendering an agreement null and void, which is what the defendant is trying to do if there's an alleged breach of regulations. Right? Lending is not illegal. Charging interest is not illegal. The legal effect of any breach of JAVSA regulations is not automatically to cancel the entire loan agreement because it's not a breach of public policy. So public policy is a very serious thing to breach, and we haven't done that here. Right? There's no issue of personal status or marriage, inheritance, everything provided for under Article, I believe it's Article 3 of the Civil Transactions Law, which is being referenced. Right? So in short, Your Honor, the claimant has freedom to contract. It used that freedom and entered into a commercial agreement with a commercially sophisticated person for a loan. Right? This wasn't a regular person who didn't have any sort of sophistication. Money was apparently being used for something for the Indian Cricket League, right? Which is a very sophisticated deal to get. No regulations were breached in doing so, and the JAVSA regulations only provide that a company cannot carry on business banking activity. It doesn't say that a company is not allowed to make a loan. But even if for the sake of argument, the defendant is able to prove that there was a breach, which hasn't been proven, the effect would not be, Your Honor, that the entire agreement is rendered null and void. As a result, we believe that this is still, it was then and as it is now, a straightforward exercise in applying the interest rate that the parties have agreed. And for that reason, Your Honor, we're seeking the relief previously detailed, as well as a detailed cost assessment on an indemnity basis. And with that, Your Honor, I rest my closing.
Mr. Mahmoud, thank you for this. Let me put this before you. It's a repetition of what Mr. Matu has said in his opening. Mr. Matu said, if you to provide or to get into a contract to provide a service, you're not licensed, you're not authorized, and actually you are stopped from doing so. You don't have the capacity to do so. So he said from that basis, you don't have legal capacity to give a loan, to get into credit agreement, to take that interest. I mean, you see what I mean? It's not like a capacity of a natural person could do, as you said, sell a car, do anything. This is like daily activity.
Well, Your Honor, we're arguing that this is the same as those other activities. It's a regular course of, it's something that can be done by a company unless it's specifically outlined that you can't provide a loan. I think my argument here, Your Honor, is that they're using banking activities, carrying on banking activities quite broadly to argue that there was no capacity to enter a loan. I think these are two different things. Carrying on banking activities and providing a loan to someone who's asked you for a loan are two separate things, right? Carrying on banking activities, if you think about it, it makes sense that JAVSA would not allow it because it doesn't have a financial services regulatory department that would be able to oversee banks operating from JAVSA offshore. So with that in mind, Your Honor, I don't think that the JAVSA regulations of carrying on banking activities necessarily means you can't provide a loan, or that a loan should not be upheld if it's done on a one-off basis or a non-regular basis.
So you're basically saying, having done so, getting into such agreement is you not act or promote as a bank. You just go in violation of your memorandum. Full stop. That's it. That's what you're saying.
At best, that's what it is.
I see what you mean. Okay, I think I thank you. This is what's troubling me for now. I will turn now to Mr. Mato, you can see Mr. Maro. Mr. Mahmoud was really brief, and he did stick to the
I will,
nine instead of 10 minutes.
I will,
But you
I will
didn't
try
have.
my best. I'll try my
You
best
can
to
go.
be.
I mean, my incentive is half an hour. If you would like to take it, it's up to you again.
No,
Mahmoud might come back again if there is anything important. He would hear from.
Of course.
I'm
And
much
again,
obliged.
Mr. Mato, I would like to remind you, if I put to Mr. Mahmoud something is not representing your argument, you may tell me, Mr. Judge, you're wrong. I didn't present it that way. Okay. For example, like the last question I put before him
fully
about
agree.
capacity.
I fully agree with your repositioning our position. Not repositioning your summary of our position.
Restating.
Restating. Sorry. Yes, I beg your pardon. Let me tackle the point. I've got to make 4 points, Your Excellency. Firstly, let me start with what my learned friend said. My learned friend said that what was done under the loan agreement is no different from my learned friend's law firm, distinguished law firm, carrying out photocopying or entering into a coffee contract with a coffee machine provider, so on and so forth. The latter being my addition. I think photocopying was one of the examples he had given.
How you like that?
We are talking about here, we're talking about banking services, providing credit on interest. It's a regulated activity within DIFC and within any of the free zones which allow such activities in the first place. The claimant chose to incorporate in a free zone which does not allow for these activities. They chose that knowing fully well the claimant's beneficial owner or one of the shareholders, as they said, is Mr. Nirmal Kumar Sethi. He is supposedly worth $10 billion. He could have an army of lawyers and advisors, as they claimed they had, to ensure that they're doing legally compliant business. Now, we say that there was no capacity at the formation. What I mean by that, there was no competent legal capacity to enter in this sort of activity, as your lordship, as your excellency restated our position. We say that it's a well-recognized rule in common law that courts will not enforce an illegal contract and provide any remedies that arise out of it. A contract will be considered illegal at its formation when it's incapable of performance without an illegal act. And I have, in my skeleton, Your Excellency, referred to a case law in support of this. A contract will be null and void and treated as if it was never entered into in a context where a entity enters into a business without license. So, for example, in the Curag Investment Limited versus Cook, it's my paragraph 20 of my witness of my skeleton argument. The defendant claimed that in that case claimed that a failure by the plaintiff to comply with certain statutory requirements relating to company registration rendered the plaintiff's contract for land of sale illegal and unenforceable. So, by way of direction, Mr. Justice McGarry, in this case, stated as follows: where a contract is made in contravention of some statutory provision, then, in addition to any criminal sanctions, the court may, in some cases, find that contract itself was stricken with illegality. If the statute prohibits the making of contracts of this type in question, or provides that one of the parties must satisfy certain requirements, e.g. by obtaining a license, so on and so forth, before making any contract of the type in question, then the statutory prohibition or requirement may well be sufficiently linked to the contract for questions to arise of the illegality of any contract made in breach of that statutory requirement. Your Excellency.
Salah, I apologize for interrupting you. I think His Excellency Justice Ali Madhani is disconnected.
Okay. Sorry.
Yeah, I
Just
was
1 second, we'll try to
disconnected.
get.
I'm here. Do you hear me? I'm around. I can't see you all.
I think your video might be frozen, Your Excellency. Well, now we can see you move. Yes.
Yeah, there's a bit of a lag, but we can hear you clearly. Or at least I can.
Oh, okay. So
Your Excellency, can I just check if you were following me in my submissions?
only for the Radusu for a minute.
Okay, let me summarize the position again.
Yeah.
Your Excellency, we say that the loan agreement was null and void at the formation because, as restated by Your Excellency, that the claimant did not have the legal capacity to enter into this agreement without valid license. License is a prerequisite, a requirement for doing any kind of banking activity in UAE, whether in free zones or outside free zones. So we rely on case law, which provides guidance on this. In Curag Investments and Cook, which is paragraph 20 of my listed, provided at paragraph 20 of my skeleton argument, where the court gave direction as to when would something like this lead to a null and void contract. It expressly states that if a statute prohibits the making of contract of the type in question, or prohibits that one of the parties must satisfy certain requirements, e.g. by obtaining a license or registering some particulars before making any contract of the type in question, then the statutory prohibition or requirement may well be sufficiently linked to the contract for questions to arise of the illegality of any contract made in breach of the statutory requirement. Your Excellency, 2 points on this case law that I have just referred to. We have seen today that there are JAFZA regulations which expressly prohibit any banking services, any commercial activity in UAE, and any commercial activity transaction with a UAE resident, which is the defendant here. Thirdly, if it expressly states, if you want to do any activity beyond your license activities, you must go and get that license, and then enter into such activities. Now, it is not a valid claim, to advance that, oh, we just breached this once and that's it. And, we had no other intention of doing anything else. It is the statutory prohibition is sacrosanct. You can't do this. It's what it says. That's what's on the tin, and that's what they signed up when they went to Jebel Ali. They knew about it. That's what we heard from the witnesses. When they wanted to go beyond their licenses, we heard today from the witnesses, in other transactions, they sought an NOC, no objection certificate, apparently, from the regulators of Jebel Ali. Now, to say that this is a matter for regulators, that's not enough. We are talking about a contract which was done, which is unlawfully, because they didn't have the license to do this. It's a regulated activity in UAE banking, whether it's done once, twice, 3 times on routine basis. You just can't do this. It's just like an individual, Your Excellency, cannot say in the UAE, oh, I just once gave a loan to some other individual at 50% interest or 30% interest. I just did this once. I'm not doing this on a routine basis. It is illegal. That's how it is applied. The law is what it is. We cannot choose to ignore when it doesn't satisfy us. Further, Your Excellency, the trade license. We have seen what the trade license says, what their own constitutional documents, which mirror the prohibitions in the rules, and they were aware of it. That's what we heard today. We heard they were aware of it. They still went ahead and did it, i.e., entered into a loan agreement which they knew they could not do. So they knew they were entering into an agreement which was void ab initio. Further, we accept that the monies that we received, it would be unjust enrichment, even though we entered into an agreement which was not legally lawful. we have to return it because that will be unjust enrichment. But the issue of interest is they're seeking a contractual remedy of an unlawful agreement, which we say they should not be given. Further, Your Excellency, even if we look at the interest provision sui generis, we will see that based on the case law that I've mentioned in paragraph 21 of my skeleton argument, it's now expressly viewed as exorbitant, unconscious, and oppressive to have a system of penalties which would render a contractual provision unenforceable. This translates into nearly 150% of interest under any legal system that's considered to be a oppressive and unenforceable penalty. In common law of United Kingdom, which does not follow Sharia law, but the effect is very similar to Sharia law, that you can't do this, in a civilized legal system, give sanctity to interest provisions which are penalty, which are not enforceable. So we say that this is if it's beyond our first few submissions, this is also unenforceable based on common law standards. Furthermore, Your Excellency, we say that even if your lordship is minded to still provide interest, given the lapse of time of 3 years since the monies were transmitted to our client, it should be a reasonable amount. The prevailing interest rate being 5% simple interest, and that is something as an alternative would be fair and reasonable. I just want to point out one case, Your Excellency. It's the Ahuja against Victory Game, which is the subsection 4, paragraph 21 of my skeleton argument, in which it was expressly stated that a interest rate, when it turns oppressive after a default, it would be considered to be illegal provision, unenforceable provision. It will not be a acceptable provision because of the effect of the interest that will be accrued as a result of it. So we say there is legally, we stand on law, we stand on the fact that the testimony provided today clarified that the claimant knew that it could not enter into a loan agreement, a credit agreement. The UAE regulations, relevant regulations, don't allow him to do it. DIFC itself, Your Excellency, it would be considered to be a illegal activity to conduct banking services, even if once without license. It is not going to, you will, if it was acceptable, an exception to law to do banking services once, then everybody in any DIFC, in any free zone or otherwise would say, oh, we have an exemption of doing this once. So there is no such exemption, and no exemption should be held here. That is all I have to say.
You're basically saying getting into a credit agreement, high interest base is a banking services. The claimants are not authorized to do so under any law, under Dubai law, UAE law, federal law, DFC law, or anywhere else.
That's correct.
That's what you're saying.
That's what we say, without it being authorized under license to provide such services and provide lending money on interest is a regulated activity for the reason it's a public policy.
And doing it once is not an excuse also. That's what you
No, there's no exception to it. Then we would see some legal provisions that my legal friend will say doing it once is an acceptable occurrence. It's not. And Your Excellency, it's not just doing once. They're seeking 36% compound interest. It's unimaginable to see this sort of provision in a normal commercial contract. So if it was allowed here, tomorrow we will see contracts where people will seek 50% compound interest because they will say we are allowed to do this once. So
right, but it's a contract your client signed, Mr. Mato.
I accept that our client signed this, but it does not negate the fact that the claimant was not allowed to do this, was prohibited to do this. It was an unlawful contract because our client assumed that they had the capacity to enter into such a contract under their license.
I think it's unlawful for both. Unlawful is unenforceable, and that's it.
That's right, Your Excellency. That's our position. That's all I have to say, Your Excellency. I'm here if you need to ask any further questions or any clarification.
Thank you very much. Ms. Mahmoud, you okay? Do you see anything, or we're done?
Yeah, I believe it's simple interest, not compound interest, which I think is a big distinction. Which is why I highlighted in my opening that, you know, had the defendant paid it within a certain amount of time, it wouldn't have been that unreasonable, right? So if he held on to it for 6 months and paid the 36%, it would have been a much lower amount. So that makes a difference in terms of the unreasonableness, whether it's excessive or not. I just like to make a note of that. And of course, if the court has any other questions, I'm happy to address them.
Can I make one point in response, Your Excellency? My learned friend used the word unreasonable because it is unreasonable. It is unconscionable, it's extravagant and exorbitant. That was our second submission, and I agree with my learned friend. It is unreasonable in any legal system to have a contract enforceable at this interest rate.
Well, Mr. Mato, he said it's unreasonable for one time only.
Well, Your Excellency, I would love to agree with you every time you say something, but on this point, I can't agree with you.
Just, 36. I mean, credit card interest rates are compounding, right? And they're far in excess of what was in this contract. So I think we have to be realistic in determining what is excessive. And the DIFC law, Article 122, says, what is excessive. So.
Yeah, right. But you're talking about a financial institution licensed, authorized, and even monitored as well. You know what I mean? So even the interest rate has to be in line with an airport rate and international rates. It's like in a scheduled, studied basis schedule that usually central bank regulate, and you know what I mean, and regulators do that. That is when you do it in that context, it's very easy to regulate. This is the main point.
That's precisely, Your Excellency, why it's a regulated activity. Because there are parameters around which credit committees assign interest rates. Because central bank will monitor your activity as a lender.
Well, I understand. See, the first position, this is completely illegal interest. He said, well, what Mr. Mato is saying, Mr. Mahmoud, it's completely illegal, and you cannot seek a damage based on unlawful contract. So at the end of the day, this is the first position. The second position, if the court minded, there should be some interest. You can't take the money for 3 years and go away. And then Mr. Mato said, then this is got to be, if there is an interest, it's got to be calculated as the commonly used interest in the markets. I mean, which is like 1 or 2% plus airport rate, for example. He said 5%. That's what he said. He said this is the usual situation. He said, but his first position is no interest at all. Second position, if the court minded that your client deserves something after three years, and then it should be according to the average rate.
Well, Your Honor, I think just to go back to this point about these interest rates being reasonable or not, the fact that it's 36% simple interest means that it's lower than some of these financial institutions that supply credit cards, right? If you take it on a compounding rate, it's actually lower. So it's not that there was benchmarked at what other financial institutions do.
And how is that? Do you have evidence in that? I mean, do we have the calculation for?
Sorry, Your Honor, can I take
very
you
complicated things to do actually. This
can I interject here just for my learned friend's sake? If I take Your Honor to the loan agreement at section E number 1556, it is compound interest. Simple interest has become compound interest on default, Your Excellency, because it says in case of default, interest will be charged at 36% per annum from 60 days of drawdown until actual payment of the loan and any outstanding interest. Default interest will be calculated on day-to-day basis and will be added to the outstanding loan every month, which is compound interest. So you add loan amount every month, and then you add the interest to the loan amount every month. And the default interest should be charged on the outstanding loan, including the capitalized interest. You see, so it is compound interest every month. That's why it's ballooning to 150% of the loan amount at the end of the payment.
So there is interest and interest at the end of the day. That's what you see. That's what makes it compound.
Compound interest, exactly. So it's not a matter of simple interest, as my learned friend is saying.
Well,
Okay, Mr. Mahmoud, your last, if you want.
We've requested simple interest in our claim, Your Honor. We haven't requested compound interest.
Okay, all I can say is, and regard of course, I think Mr. Mahmoud, you want cost and contingency basis and.
That's right, Your Honor. That's correct, Your Honor. I think given it's been such a long time and so many procedures have been taken by the defendant and subsequently claims dropped, we believe it's appropriate to request a detailed cost assessment on an indemnity basis.
Well, I hope my learned friend, Your Excellency, doesn't presume that Your Excellency has given a decision in his favor. I suppose for that we have to wait for His Excellency's determination of the matter. I think that would be appropriate at that point.
I was not criticized for being optimistic, Mr. Mato. I don't know.
I wasn't being presumptive, no.
Yeah.
I mentioned it only because Your Honor brought it up. Yeah.
I'll tell you something. I would reserve for judgment. And I would invite you, if I would depart from the usual cost criteria, I would invite you for submission. If I take normal cost assessment, then that's it. But if I would think to depart from, I would invite you to submit short submission, and then I'll make my mind. Thank you very much for today.
Your Excellency, thank you for everything.
It's an interesting case. It's an interesting point of law. And I thank you for your very well prepared presentation.
Thank you for your guidance and for your support throughout the trial and before the trial. I would take the liberty to thank on behalf of my learned friend and myself, and on behalf of all of us, for your consideration, for your time, and for your assistance.
Oh, that's our duty. I thank you for your collaboration and making it things. I mean, you stick to the timetables.
And I'd like to thank my learned friend and his legal team, respectively, as well, who have been cooperated with us at every juncture. So thank you very much for everything.
We're grateful for your cooperation, Salah, as well.
Thank you, Mr. Sethi.
Thank you, His Excellency, and I was. Thank you so much, and and thank you, Mr. Kareem and Mr. Salah, for your time and listening to us. Thank you, sir.
Okay, you hear from me soon. Thank you very much.
Thank you, sir.
Thank you, Excellency.